Can you see and hear us?
Yes, thank you very much.
May I call Tim Parker, please?
Of course.
Sincerely and truly.
Sincerely and truly.
Declare and affirm.
Declare and affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
So before I ask questions of Mr. Parker, I should say that there is a fire alarm drill today at 10 o'clock, and in accordance with our usual practice, we're going to sit through it.
Sure.
Thank you. Good morning, Mr. Parker.
Morning.
My name is Jason Beer, and I ask questions on behalf of the inquiry. Can you tell us your full name, please?
My name is Timothy Charles Parker.
Thank you. You've provided kindly a witness statement for us, which is 136 pages long. The URN for that is WITN 00690100. You should have a hard copy in front of you there. Can you turn up, please, page 126? Do you have that?
I do.
And do you see in paragraph 268, Roman 3, it says Poll appointing a criminal with extensive experience to work alongside Brian Altman QC?
I do.
Should that have the word silk inserted between the word criminal and with? So,
most certainly.
So that rather than the Post Office appointing a criminal, the Post Office would appoint a criminal silk?
Absolutely. Correct.
Thank you very much. Can we go to the last page, please? Which is page 136. Is that your signature?
It is.
And with that correction brought into account, are the contents of the witness statement true to the best of your knowledge and belief?
They are indeed.
Thank you very much. It's a very detailed witness statement of 136 pages. It will be uploaded to the inquiry's website, and therefore I'm not going to ask you questions about all parts of it.
Okay.
Can I start with your background, please? You were chairman of the Post Office from the 1st of October 2015 until September 2022, so about 7 years, is that right?
Correct, yes.
You took over after Alice Perkins was chair of the Post Office, albeit there was an interim chair.
That's correct too.
At the same time, I think you were chair of Samsonite. I think you became chair of Samsonite in 2014, is that right?
I was, in fact, chair and chief executive of Samsonite from 2008 until 2014, and then I stepped down as CEO and remained as non-exec chair.
So chair of Samsonite from 2014 until the present day?
Today, yeah.
Yes. And so concurrently with your term in the Post Office for 7 years?
Correct.
You were concurrently chair of the National Trust, I think, from 2014 to 2022, is that right?
That's also correct.
So again, concurrently with you being the chair of the Post Office?
Indeed.
And from April 2018, I think you were chair of Her Majesty's, now His Majesty's Courts and Tribunals Service until 2022, is that right?
That's also right.
So concurrently with your chairmanship of the Post Office for a period of 4 years?
Correct.
Thank you. Can you tell us in general terms your view of the company, the Post Office Limited, that you inherited when you took over as chair in October 2015?
Yeah. I mean, the Post Office has a turnover of just under £1 billion, which makes it a sort of medium-sized company. But in fact, it is an incredibly complex business. It's complex because it operates a network of around 11,500 sites. It's complex because it has a very wide range of products. It's complex also because it deals with cash, and cash has a big security element to it. It's complex because it's in the public sector. So this is an organisation that is incredibly complicated and at the same time faced some very significant commercial challenges. Sorry, I'm going on a bit here, but
No, that's right.
it's quite important that I can set the scene to the Post Office. This is a business which has absorbed billions of pounds of taxpayers' money and was still losing money. It was a business that faced significant challenges because it had an exclusive arrangement with the Royal Mail, and the Royal Mail itself was suffering from increasing competition in the parcels market and a declining letters market. The Post Office had previously had a significant amount of business from the government, so driving licenses, benefits, that kind of thing. That had all moved online, and so the Post Office was bereft a significant chunk of its contribution. The Post Office had a range of products which it attempted to sell with varying degrees of success. And it also had a very complex structure in terms of its overheads and management. So when I turned up, I felt and I believed that I could somehow help to improve an organisation that was in, I don't think it's any exaggeration to say it was in deep crisis.
Thank you. I think it's right that before you took up your position, you made inquiries as to the accounts or figures of the Post Office before accepting the role. Do you remember that?
I don't, but I probably would have done.
Let's look at some emails to jog a memory, if we can, please. UKGI 301 9884. And if we look at the second page, please, and the bottom half of the page, that's it. This is an email not sent to or by you, but it's about something that you are said to have said. It's from Laura Thompson, who was an assistant director within SHEX, the shareholder executive.
Sure.
It's to the essentially private office of the then Secretary of State, Sajid Javid, and you'll see it's dated the 17th of June 2015. Mm-hmm. So 3 or 4 months before you took the post. Mm-hmm. Mm-hmm. And if we just read it, we spoke, Baroness Neville Rolthew, I think you'll remember, was the relevant minister at the time. Mm-hmm. Met the 2 appointable candidates earlier today. We spoke to the minister after her meeting. She'd confirmed that she would be happy to appoint Tim Parker to the role, but did not feel Simon Burke was suitable. While he had some very good experience, he didn't give her the confidence that he would be a strong chair. She felt he would need more support from government in steering the business. Then second paragraph, I would be grateful if you could therefore seek the Secretary of State's views on the appointment. Please note that Tim Parker expressed an interest in seeing some more up-to-date figures on the Post Office before accepting the role if he were to be offered it. We believe this is just thoroughness on his part. He needs to be confident what he is getting into, and we're following this up with Post Office and with the Public Appointments Assessor so that we can answer his queries. And then I'm not going to read the third paragraph. What were your concerns about the finances of the Post Office? What were you concerned about getting yourself into?
Well, as I think I've described to you, it was, I felt, in a very difficult situation, compounded by the fact that it relied obviously on agreeing financing, usually on an annual basis with the government, and needed a subsidy really to keep everything in order. So I thought it was a difficult situation, and it certainly wasn't going to be very easy, but I felt that however things turned out, the government would obviously need to stand behind the Post Office. And so I would be trying to help the executive team tackle things from the commercial end of the business with the customer, and at the same time try to manage the government and its willingness to finance the Post Office.
So is this an oblique reference then to whether the government would continue properly to subsidise the Post Office?
Yeah, I believe that post offices are very politically sensitive, and keeping a network is usually of significant importance to ministers. So I always felt that, you know...
If you just pause there.
Attention, please.
Mr. Parker, you just said, I believe that post offices are very politically sensitive, and keeping a network is usually of significant importance to ministers. So
Yeah.
I always felt that.
Yes, and I was going to go on and say, so I always felt that although there would be some very difficult discussions, the Post Office would always be there in some form or another. The challenge was to try to essentially make it more sustainable.
When you were essentially doing this pre-appointment due diligence, were any concerns expressed to you about the performance and capabilities of the then CEO?
I don't recall that being expressed to me at the time.
Can we look, please, at UKGI 304-2677? This is a presentation about Post Office Limited senior management to the Risk and Assurance Committee of the Department for Business Innovation and Skills and the shareholder executive. You'll see it stated February 14, so a year and a half or so before your appointment. Can we turn, please, to the second page? And do you see down the left-hand side underneath the number 1, advice from the recent annual review suggested that the Post Office team give careful consideration to the continued suitability of Paula Vennells as CEO. There is a general consensus that Paula is no longer the right person to lead the Post Office, but justification is anecdotal. This short paper aims to examine the options available to the shareholder executive. Was anything like that brought to your attention upon your appointment?
Not that I can recall.
Can we go forwards, please, to page 6? Again, on the left-hand side, I should say that there's a series of options presented in this paper, one of which is removal of Ms. Vennells. and this is the slide that addresses that issue. On the left-hand side, there is a general feeling that Paula is not the optimal person to lead the Post Office to deliver its commercial strategy. Paula has not been able to establish good working relationships with Joe Swinson. She has been unable to retain key staff. And then on the right-hand side, performance as CEO and delivery of strategic plan. Post Office failed to deliver its 2010 strategic plan and refused to keep the government properly appraised of developments in the network transformation programme, requiring difficult revisions in 2013. She's shown a worrying lack of knowledge about the detail of the new plan. Paula's people management has caused concern as she appears unable to work with personalities and approaches that differ from hers, and has failed to build relationships with key directors. And Paula's performance as CEO has been questioned by the poll chair and by members of the board. Were you aware of this view held by the department and or SHIEX when you joined the company?
To be honest, I mean, looking back from here, this would have been 2015, so we're talking 9 years ago. I can't recall a conversation that I had about the capability of Paula Vennells at the time I became chair.
Would you expect, as the incoming chair, to be told that by the outgoing chair that she had questioned the chief executive's performance as chief executive?
I think it's obviously of some value if, when you arrive in a business, you are well appraised of the views of your key shareholders, whether it's a publicly owned business or not.
That's a statement in general terms. I'm asking, were you in fact told by or on behalf of the outgoing chair of this view that is recorded here that she held in relation to Paula Vennells?
And the honest answer to that is I can't remember.
Was there a handover?
I met Alice for lunch before I began.
Was that the handover?
As far as I can recall, that was the conversation that I had with her.
Was there anything more formal than lunch in terms of a handover?
Again, I'm sorry not to be of more help, but I can't recall.
When you walked into the company, we saw that you did some work in the months before your actual appointment. Did you make any inquiries about this issue, namely the performance of the CEO and or the board's view of her and or the shareholders' view of her?
I can't recall. Can I make a comment on that? Because it has struck me, and this is something I hope might be of use to the inquiry, that whether or not I received a view or whether I took on board a view, it is very important that when you take over as chair that you are well appraised and you understand as best as possible the views, positive and negative, of the CEO. This, I think, can help to frame things. As far as I can recall, and I've got quite a lot of experience working with CEOs, and I've been a CEO for over 30 years. I mean, my take was that the business had someone who needed some help and assistance and coaching on the commercial front, which is what I aimed to provide Paula. My impression, looking back, was that she was quite well thought of, and so much so that, as you probably know, I mean, a few years later, she was made a non-exec director of the Cabinet Office. And, so my sort of feeling was, although whatever my own views were of her ability in terms of running a business, I didn't get the impression that there was some enormous doubt. And, the starter for 10 was actually you need to look at Paula.
Okay, that was my next series of questions. When you did become chair of the business, was anything like this raised again with you by government or the shareholder executive?
Yeah, and again, I'm sorry, at this length of time, I simply cannot confirm anything.
Can we move on, please, by looking at UKGI 5361? At the moment, I'm just looking at a series of events that happened before your appointment. If we can go to page 4, please. This is a series of emails that, again, doesn't involve you, but there are within the emails comments and views attributed to you, and I want to ask you about them.
Yes.
Below this page, there's a note about an upcoming panorama programme. There was a significant panorama programme about Post Office and the Horizon system due to air on the 17th of August 2015. And if we go to the bottom of page 3, please. Alwyn Lyons to Richard Callard, that will be a name familiar to you, within the shareholder executive, exchange an email copied to Miss Vennells. Richard, Paula and I are considering how and when it is best to brief Tim on Panorama. Would you let me know when Baroness Neville-Rolfe is planning to speak to him, as she was going to mention Sparrow. Notification re Panorama would come better after that, as we could refer her to her conversation and offer a more immediate brief if he would like one. Then further up the page, please. The reply, BNR, Baroness Neville-Rolfe is speaking to him, that's you, at 2:45 today. I spoke to him. He is pretty robust on Sparrow, i.e. if we've done nothing wrong, then we stick to our guns. But he's happy to agree for Baroness Neville-Rolfe to say to Bridgen and co. That the new chair will, of course, take a critical and independent look at the issue. He also did offer to sit in with her in her meeting with our Buthnot, which was arranged late yesterday for the 17th. We should all mull that one. So essentially, consideration is being given as to how to brief you about an upcoming panorama programme, which is very significant for the business. And so do you recall receiving briefings before you formally began your role, a couple of months beforehand?
Candidly not, no.
It's attributed to you that you are, quote, pretty robust on Sparrow. Was that your view?
I have no idea. I mean, at this stage, I'm not sure what I would have known about Sparrow or indeed what pretty robust actually means. I think probably what it means is, I'd obviously been briefed up to a point, but I wasn't going to say anything negative or positive at that stage because I was very new. And maybe that was interpreted as pretty robust.
I was about to ask you, on what basis would you have formed a view 2 months before you joined the business?
I don't think I would have done.
Because you hadn't read or received any relevant information, presumably?
I have no idea, but I mean, I'm not a person generally who takes a predisposed view to anything until I've had a chance to understand it properly.
If we go up the chain, please, to page 1, and the foot of the page. Later on the 6th, again, Laura Thompson to Alwyn Lyons and Richard Callard, I've just come off the call between the Minister and Tim Parker. Nothing significant to report. On Sparrow, the Minister informed him that she would like him to look at things with fresh eyes when he arrived, which he was happy with. Tim confirmed he would be happy to meet MPs, etc., on the matter, but once he was up to speed. The Minister mentioned that Panorama was happening, but it wasn't discussed. And then there's another issue about the Audit and Risk Committee, which I'm not going to ask you about. Do you recollect the Minister, Baroness Neville Rolfe, asking you to look at things, i.e. connected to Horizon? That's the shorthand for Sparrow that the Post Office used.
I don't recall. I mean, I presume this is a fair reflection of what I might have discussed. I mean, I think she would have just notified me it was an issue.
Do you have a recollection of going into the job with a request from the government to have a fresh look at Horizon?
I don't recall whether I, as it were, went into the job, but I do know that the letter turned up pretty soon after I arrived.
And so that's the thing that sticks in your memory, the letter from Baroness Neville.
Got a letter, and it was clear. You know, have a look into these issues. Exactly.
Okay, we'll come to that in a moment. Can you recall anything as to what the concern was in government about Horizon?
Not specifically.
Can we move forwards, please, to poll 00319054? And if we go to page 2, please, and scroll down. This looks like the genesis of a briefing note for you about Horizon. Again, it's called Sparrow. In readiness for your joining. We're going to track through what you were told. And if we just read some parts to it, this is Mark Davis. Do you remember him?
I do.
The Corporate and Communications Affairs Director in the Post Office. See below a first draft of a note for Tim. For the last 3 years, this is the text of the note. For the last 3 years, the Post Office has been investigating the cases of a small number of postmasters, and then we see somebody's added, I would add how many, who have suggested that the Horizon system used in branches might be faulty. They've suggested it may have caused losses in branch, which in some cases led to them being prosecuted. Again might be worth saying how many. No evidence has emerged to support these claims. Indeed, thorough investigation has underlined that the system is efficient and robust. It deals with 6 million transactions every day, and it's been used by almost 500,000 people since it was introduced, the vast majority doing so without difficulty. The Post Office has nonetheless taken its responsibilities to its people very seriously. It's very sorry that this small group of people feel they've been treated unfairly and has gone to enormous lengths to get to the bottom of their cases. It held a review by independent forensic accountants, set up a mediation scheme overseen by independent mediators, and reinvestigated every complaint in huge detail. We've also asked our external lawyers to review all the cases involving prosecutions. Throughout all this, no evidence has emerged to support the very serious allegations being made, which in some cases have stretched to claims that the Post Office has abused the prosecution process. Over the page, we do take forward prosecutions where it's right to do so. Post offices are dealing with public money. We would be heavily and rightly criticised if we didn't deal with the very small number of cases where false accounting and theft takes place. But we only prosecute where there's clear evidence of wrongdoing, and we can meet the bar set for bringing prosecutions, the evidential and public interest tests. We do not prosecute people for making mistakes. We prosecute where people dishonestly cover up the loss of money. And then scrolling on, if we scroll down, keep going. And then the fourth paragraph from the bottom there, The campaign has secured the support of some MPs with whom the Post Office has engaged at length, which has in turn led to parliamentary and media activity. We've been robust in rejecting the serious allegations made in Parliament and the media, particularly in recent months. The allegations have suggested wrongdoing by senior management, bullying, deliberate cover-up and abuse of prosecutor powers. Panorama programme is due to be aired on the 17th of August. We've challenged the programme at length, but expect it will go ahead. We've provided detail on every allegation put to us. We're not appearing on the programme for interview because the programme is focusing on individual cases and has not provided evidence to support its allegations. Is this the kind of note that you would expect to receive as the incoming chair?
I think it's obviously a note that is designed to tell a story, and what would I say? I mean, it's a briefing note, obviously told from the perspective of the people providing the briefing, which is what usually happens with briefing notes, I have to say.
If we just go forward to page 1, please. Just look briefly at some of the drafting process, foot of the page. Olwyn Lyons to Mark Davis and General Counsel Jay McLeod. I think this is very clear. She's added some points in capitals. I think this note should come from Jane, or if Paula, if she wishes, and sent via me to start getting him used, that's you, to that way of communicating and make it as, quote, normal as Sparrow can ever be, and then scroll up the page. We need to send a note to the new chairman. I've drafted a first go and asked for comments. I'd like your comments and whoever is standing in for Rod. Clearly, this is about the most important note we will send on this issue in the weeks ahead, so we want it to be spot on. Your input very welcome. When you were joining, was the Horizon issue, the Sparrow issue, the most important issue for you?
I've tried to set the background to the Post Office, and I would say I can't prioritise things exactly. I would say this is one of actually a number of very significant and pressing issues.
If we go forwards, please, to poll 0023 1055. And if we just blow that up a little bit. This is a later iteration of the note after an external lawyer, Andrew Parsons, from Womblebourne Dickinson, as I think they were by then, with his comments on it. And he makes quite limited comments on the note. We can see one on the right-hand side there. If we go over to page 2, please. Thank you. There's some discussion about destruction of material. The note said, we're not destroying any information that we and external lawyers hold on these cases, as has been alleged. And then he commented, the Post Office has historically destroyed information where it went beyond normal retention periods, which means some info is not available to the CCRC. Now, of course, you wouldn't see all of this background, would you? You wouldn't see the process by which the note was created, or indeed who had contributed to it, right?
Yes, I mean, absolutely.
You just get the final product.
I get the final product, exactly.
Let's look at that then. Poll 00174396. Uh, 11th of August 2015, so nearly 2 months before you joined the company. from Alwyn Lyons, please find attached a note from Paula in advance of the Panorama programme, and then some other information. And then if we look at, ultimately it's a note from the Chief Executive being sent to you by Alwyn Lyons, the company secretary. If we look at the note itself, poll 00174397. Thank you. Post Office for the last 3 years has been investigating claims made by a small number of largely former postmasters, and then you see the figures have been inserted, 136. That faults in the Horizon computer system were the cause of losses in their branch. Of these 136 people, 43 have criminal convictions. However, thorough investigation has not produced any evidence to support the claims. Indeed, it has underlined that the system is efficient and robust. In cases involving criminal convictions, nothing has emerged to suggest that any are unsafe. And then it continues as per the previous draft. Again, how would you view a document like this? You described it earlier as a story, which might, to my ears, sound as if you're being wary as to its authorship and it setting out a narrative rather than be completely objective. Is that what you were intending by the word story?
Not especially, but here's my view with hindsight about one of the main issues with the whole thing is that as I sort of looked at this, it seemed to me that it was an issue. But of course, you ask yourself the question, well, on how big a scale is this issue? And of course, what we have here is the Horizon system deals with 6 million transactions used by 500,000 people. So it sounds as if you've got a system doing millions of transactions and a few people who are complaining. And that was the sort of perspective that you're drawn to. And I say this in the spirit of, if this thing ever happens again, is had the thing been put in the context of not just the people who are complaining, but the totality of the people who had been prosecuted over to, whatever it was, 15 years, that would have put a very different complexion on the note. So if the note had read, we have 43 criminal convictions related to these losses, but actually over the last however many years, so many people are being convicted, that would have told a slightly different story. And I also think that there could have been more to this potentially around how many people had been affected through potentially any other sort of employment-related issue. So we've looked at the Horizon problem from the point of view of, well, what was, did the computer have bugs or whatever? But actually, another way of looking at it might have been, say, we've got an organisation, over 15 years, 900 people have been convicted or whatever. How does that look? Does that look statistically sensible? We've had, so many people who have been terminated or whatever. How does that look proportionately? And so I looked at this, to be honest, and not only did we have millions of transactions, but I happen to know over the last, there were tens of thousands of postmasters and assistants. So it looked vaguely credible that there was a sort of a problem that affected, relatively speaking, quite a small number of people.
The reflections that you've just given there, are they things that have occurred to you now in the light of the events which have happened, rather than things that occurred to you at the time?
well, I didn't have that information at the time. And actually, it was quite late in the day, and I think quite a lot of people at the post office were quite surprised by how many people had been prosecuted. And if you look at the sort of list of when the prosecutions occurred, you go back to, I think that I looked at this list, and it sort of, from, I think it was 98 or 99, the numbers of people being prosecuted suddenly went up. So it went up from 20 to 50. And effectively, what you're looking at is a record from about 2000, I think, roughly speaking, until 2012 or some 13, something like that, where, roughly speaking, 50 people are prosecuted every year. So my point is obviously that's something that might have raised some question marks. Now, you have to recognise as well that the post office, you know, it's not selling cans of Coke. It's actually an organisation that deals in cash. And so you have to be aware of the fact that obviously when people are dealing with cash, there are issues with security and there are temptations to people and so on and so forth. Notwithstanding that, I think had that picture been evident, it might have sort of made people, certainly would have made me, look at this in a slightly different context.
Would other things that may have made you look at this in a different context include, rather than focusing on the number of sub-postmasters that were presently alleging faults, being only 136, to look back at the number of sub-postmasters over the relevant period that had alleged faults?
I think that's the point I'm trying to make. It was quite difficult to frame the scale of the problem.
Or mention of the operation of a series of helplines which recorded tens of thousands of complaints of fault.
That wasn't dealt with clearly in this
No.
context.
Did you know at the time that this note had been drafted by the Post Office's communications man, Mark Davis?
If it didn't have Mark Davis's name on it, then I'm not sure I would have adduced that it was him who wrote it. No.
I mean, you were told in the covering email, this is a note from Paula.
I think so, yeah.
Yes.
Yeah.
Would it have surprised you if it had been revealed that the note had been drafted by the communications man?
That's an interesting question to which, I mean, it's very hard for me to say now how I would have felt, because when you're new in an organisation, you're never quite sure, you know, who's got a handle on what. So I think had I had a list of all the executives and, you know, Mark Davis was identified as the comms man, I might have wondered a bit.
As it was, you were told this was Paula Vennells' note in the covering email, as we saw. Can we turn, please, Mr. Parker, to the letter that you mentioned earlier from Baroness Neville Rolfe, Poll 00102551. So this is about 3 weeks before you joined, 10th of September 2015. And I'm going to read it all. I'm writing to you ahead of your taking up the role of Post Office Chairman to confirm our conversation last month regarding the Post Office Horizon system. I suspect that's a reference back to that mention we saw in that email exchange. The issues surrounding the Horizon IT system have not been resolved. Indeed, some of the MPs concerned have written to me again following the Panorama programme, pressing the case for an independent investigation. The government takes seriously the concerns raised by individuals and MPs regarding the Post Office Horizon system and the suggestions that there may have been miscarriages of justice as a result of issues with Horizon. The government also recognises the commitment that Post Office has demonstrated to resolving those issues, including through creating a mediation scheme and appointing independent investigators to scrutinise the system. As you'll be aware, there have been some 3 years of scrutiny of Horizon, and the Criminal Cases Review Commission is considering a number of cases which have been brought to it by individuals, and the government cannot intervene in that independent process. As the sole shareholder of Post Office, the government wants to make sure that the Post Office network is successful and sustainable across the country. We recognise that the Post Office is a commercial business and we allow it to operate as such. But of course, we expect it to behave fairly and responsibly in doing so. I'm therefore requesting that on assuming your role as chair, you give this matter your earliest attention, and if you determine that any further action is necessary, we'll take steps to ensure that happens. I look forward to hearing your conclusions and to working with you to secure the future of the Post Office network, and then Paula Vennells is copied in. So this letter, if we go back to page 1, draws to your attention that there were unresolved issues regarding Horizon.
It does.
And that those unresolved issues include potential miscarriages of justice.
Indeed.
This must be a slightly unusual letter to receive when taking up a new job.
It's very unusual. I mean, I'm not a lawyer, obviously, and I think, again, in the spirit of trying to be helpful to the inquiry, I've had sort of legal issues to deal with, but nothing, on this sort of scale that involves activities ultimately that have affected, people, contracts, going to jail, and all of that. I mean, it's just not usual in the slightest.
Your witness statement, I'm not going to turn it up, I'm just going to read from it, says at paragraph 28, when I was appointed as chair, I was aware that concerns had been raised about Horizon, including those relating to Fujitsu. I do not believe that I had detailed knowledge of the specific nature of the complaints at the time, and I do not believe I'd formed any views on how to handle the Sparrow issues at the time. However, as I described below, Jonathan Swift QC and Christopher Knight were being instructed in relation to the Swift review. My recollection is that there was a general assumption within the Post Office that there were no systemic issues with Horizon and that it was robust. And this is consistent with the statements made publicly by Post Office at the time. So my recollection is that there was a general assumption within Post Office that there were no systemic issues with Horizon. Where did you get that belief from?
I can't tell you. I'm looking back, 9 years trying to sort of assess how I felt at the time. And I think, of course, it comes back to this question of what do you mean by systemic? Systemic, and perhaps, in a computer system, means different things to different people. And I think you probably, had quite a few people pass through here. And I think systemic became shorthand, and I was probably, affected by this as much as anybody. Say, yeah, the system worked fine, and what do you mean? It means that there are a few bugs, they're not very frequent, they're discovered, and, so basically you've got something that's okay. That sort of thing. So you've got no recollection, particularly now, as to where you secured the belief from that Post Office had a general assumption that there were no systemic issues with Horizon and it was robust. Presumably that would include, however, the briefing note that we saw that Mark Davis had drafted. And that must have contributed. I honestly can't, it's just hard for me to reflect accurately on a generalised picture that I would have had at the time. I've probably gone as far as I'm able.
You were presented with something of two pictures then, would you agree? One, a general assumption within the Post Office that there were no systemic issues and the system was robust, and the government saying the issues around the Horizon IT system have not been resolved. We, the government, take seriously the concerns that are being raised, and those concerns include potential miscarriages of justice.
I think that's a fair description, yes.
When you joined the company, were there any specific discussions that you can now recall, this is in October time, about Horizon issues, whether as part of an induction or otherwise?
I can't.
Were you provided with the report or reports by Second Sight, either an interim report of July 2013 or two final reports in 2014-15?
I can't.
Were any concerns raised with you upon joining or immediately thereafter about the use by the Post Office of a man called Gareth Jenkins, a Fujitsu employee, as a witness in criminal prosecutions?
No.
When did you first learn about the issues that there were, I'm putting it broadly, with the use of Mr. Jenkins as a prosecution witness?
Oh, I mean, way past this sort of time scale. I mean, I'm talking, I mean, I can't tell you exactly when, but my sort of awareness of the definitive situation, I think, where of Jenkins and evidence and all of that, that was some time afterwards.
In the context of the group litigation, or even later than that as part of the criminal appeals to the Court of Appeal?
I can't tell you, to be honest.
What did you think upon receiving this letter?
Time to get moving. Which
what did you need to move to do?
To find somebody, because I was certainly not equipped personally to do this, but to find somebody to carry out what I was asked to do.
Was it always your intention from the start that another person would conduct some form of exercise and that person would not be you?
Yes, I think so. I think so because there were a lot of issues here that I wasn't really familiar with. So I'm not a legal person. I'm not an IT person. And I'm not somebody who's got a lot of experience dealing with this sort of, if you like, non-commercial area. So my first instinct, yes, was, what sort of person could do this job?
Can we turn, please, to poll 306-5606? And if we scroll to the email at the foot of the page, again, an exchange not involving you, from Roderick Williams. Do you remember him?
I remember the name, yes.
A solicitor in corporate services, or specialising in corporate services within Post Office Legal. To Jane McLeod, do you remember her?
I certainly
General Counsel.
I certainly remember Jane McLeod, yeah.
Mark Underwood, do you remember him?
The name rings a bell, but not a big one.
And Patrick Bork.
I remember Patrick.
Performing what function, do you remember?
He was in Jane's team. I don't recall specifically what his role was.
In any event, this is a fortnight to also, yes, it's exactly a fortnight after that letter of the 10th of September. And it concerns speaking notes for a Jane McLeod and Tim Parker meeting on the 25th, so the next day. Can you see that? Please see below my starter for 10 speaking notes with your for your meeting with Tim Parker tomorrow, draft speaking notes. Post Office can't influence or predetermine the outcome of Tim Parker's review, but it's reasonable to assume that the findings will be challenged unless they deliver what James Arbuthnot wants, quashing of convictions and payments of compensation. See James Arbuthnot's attributed comments about the criminal cases review, commission review of Josephine Hamilton's case. However, if the purpose of the review is to still in confidence in Biz, principally Baroness Neville Rolfe, with the actions taken, it will be creditable if it's A, undertaken independently of the existing Post Office team, B, logical in its approach, and C, delivered against stated objectives. This will help defend any criticism of the work undertaken, e.g. it's just another whitewash, and curtail further involvement. So just stopping there, did you understand that there were two alternatives to what the review might seek to achieve? One, to actually deliver what James Arbuthnot wanted, or two, instilling confidence in the department, principally Baroness Neville Rolfe?
I think we're talking about, I mean, it's just my take looking at this, two different things though here. I mean, if you read 2, it says it's reasonable to assume that the findings will be challenged unless they deliver what JA wants. So that's an observation about findings, isn't it? And, you know, finding an assumption that the review would lead to those findings, whereas 3 is about the purpose of the review. And it seems to me that it's, you know, one's in danger of sort of confusing two things. One is what the review comes to, and the other is what kind of review. Now, if you hadn't seen Para 2, you might say, well, 3 seems, actually, it's pretty reasonable.
Was the review to find out the facts, or was its purpose to instill confidence in the department?
So, again, if you read 3, it says, however, if the purpose of the review is to instill in Biz, principally confidence with the actions taken. So that's slightly different from just general confidence. I would see that as a, you know, I could read that as a genuine desire to ensure that whatever actions were taken, they look to be on the basis of a proper independent review.
What was your purpose in commissioning the review?
So I had a letter that asked me to look into these various issues, and my purpose ultimately was to find somebody I felt qualified to do that and to agree with them terms of reference which seemed to broadly tackle the challenge laid down in the letter.
If we read on 5, defining the review scope would be key. What has Tim Parker been asked to do? And then over the page, it's unclear. Sorry, if it's unclear, Tim Parker should now set out in writing his understanding of the task, i.e. rewrite the exam question. B, what will Tim Parker actually do? Tim Parker should state what he wants to achieve, ideally by reference to a clear question, e.g. has the Post Office responded to allegations about the integrity of Post Office's Horizon system and related business processes in a manner appropriate for a business which desires to maintain a reputation for high standards. And then there's a comment about a paraphrase of 3.4e of the letter of appointment being clunky. Tim Parker should be able to demonstrate that he has addressed his stated aim by reference to a logical method of investigation. Both elements should be matters for Tim Parker and his sole discretion as chairman, e.g. They are not for negotiation with Post Office, Baroness Neville Rolfe or the department, etc. We can read C.
Yeah.
6, given the volume of material, Tim Parker is likely to need independent professional assistance. He's entitled to this under his letter of appointment. This could be, scroll down, a solicitor, a barrister, a management consultant, or a former civil servant. And the pros and cons are set out for each of them. This plan, it seems, was to have you carrying out the review, but assisted by some professional or professionals. Do you agree?
I'm not sure I draw that conclusion, actually. I'm not sure even if this piece of paper makes it very clear how, as it were, the workload would be divided between whoever was going to do the assisting, as it were, and myself.
Did you ever think that you would perform any role, or were you always of the view this was going to be subcontracted out to some other person?
Yes, I felt that the task at hand carried out by somebody independent, because although potentially I could be independent, what was quite important here was to have not only somebody who was independent, but might have a few of the skills around the subject matter that I lacked.
When you were engaging in discussions with, for example, Jane McLeod and Roderick Williams, did you realise that they may themselves be implicated in the matter to be investigated?
So I think that's a fair enough observation, but here are two things, and I suppose quite a lot of this inquiry is dealing with this kind of issue, which is if you're a board member, a chair or chief executive, to what extent are you entitled to assume that your advice is coming from people who are, first of all, qualified, and secondly, competent? And my take, perhaps naively, because the one thing that I've found in most businesses is that although people have got different points of view, they're generally trustworthy, is that I was being given advice by people who were qualified on that basis. And so was I kind of a little, did I feel that this advice would somehow be potentially tainted? I don't think I did feel that at the time, if I'm honest.
Did the thought occur to you, or is that a reflection now after the event?
It's a reflection after the event. I think, obviously, after what has happened, it's likely to throw into doubt quite a lot of the advice that was given and taken in good faith. I mean, if you go back, am I allowed to do this?
Yes, you can do whatever you want.
Well, if you go back to the beginning of this note, I just want to give you an illustration of that.
Yes, if we go back to page 1, please.
So, sorry, to move up a little, scroll up a little bit further. I'm not seeing what I wanted to show. Sorry, I beg your pardon. Just keep scrolling up.
When Mr. Parker says scroll up, I think he means scroll down.
Do I? I'm sorry.
That's
yeah. So it's under the what has TP been asked to do, I think, number 5. If we move on to that. Okay. So I mean, without the benefit of hindsight and with no knowledge of this, you could read B as actually, a pretty fair-minded kind of view on what needs to be done. He should, just read it. It should state what he wants to achieve, ideally by reference to a clear question, and so on and so on and so on. And another factor, I suppose, in all of this, perhaps, wrongly, was that Jane McLeod joined the Post Office, I think, in 2015. So, I'm not sure. I sort of felt she was a kind of, she was a fairly new arrival. and she seemed competent to me. Yeah.
So are you saying that that first bullet point, TP should state what he wants to achieve, e.g., and then the exam question is rewritten? You could read that in a benevolent way now to be an appropriate question to ask and to answer, or you could read it as a reframing of the issue, so as not to look at the substance of the issues, but instead to look at the response of the Post Office to the issues. They're very different things, aren't they?
No, I understand your point. And with hindsight, of course, you might say, well, the problem with Swift was that it was really just about the complaints. Understand that. But at the time, it seemed to me, you know, a reasonable place to go.
Is that distinction, the one that I've just drawn, that what was required by the minister's letter was to look at the substance of whether the system had integrity and whether the prosecutions made on the basis of Horizon data were safe, is a very different question to examining the Post Office's response in the past to allegations.
So I think, I mean, again, with hindsight, you might say, well, the minister's letter was all about the system, and we should have just done an IT check and a contract check, and everything would have been fine. But actually, the way the minister's letter read and the way I interpreted it, and felt we were interpreting it appropriately, was to look into the complaints and the issues raised by the complaints, and essentially, you know, that's where Swift went.
Can we move forwards a little bit to the same part of the narrative, but post-appointment, to poll 0011 7516? Bottom half of the page, please. An email to you directly from Paula Vennells, sent by her executive assistant. Dear Tim, while you've been away, two matters have arisen affecting Post Office, which you should be aware of. I should say this is the 9th of October 2015. I'm grateful to Jane, that's Jane McLeod, for the following brief summary. Sparrow. The Minister is under pressure to speak to various parties, including representatives of Second Sight, forensic accountants, and Sir Anthony Hooper, former chairman of the working group. We believe that as part of your investigation, you should meet with each of these parties, and we have therefore recommended to the Minister that she should not meet with them until at least the conclusion of your inquiry. I have a call with her this morning and will recommend that she should await the conclusion of your inquiry before deciding whether to meet with them. There are a number of reasons why we're reluctant for the Minister to speak to these parties, particularly Second Sight at this point. By speaking to these parties, the Minister undermines the rationale for your own independent investigation. Second Sight are active on social media, and we believe they would make public the fact of any such meeting. This will only encourage expectation of some form of government intervention. We now have the majority of outstanding non-criminal cases scheduled for mediation. Any expectation of government intervention is likely to cause applicants to withdraw from the mediation scheme. I'll send you an update, and then the email turns to another topic, like a mobile, which is something over the page about an entirely different issue. So Paula Vennells was seeking to delay the Minister from meeting with Second Sight and Sir Anthony until after your inquiry had concluded. Did you have a view as to this?
If I did, I can't recall it now.
Did you see the two of them, two issues as linked? Second Sight and Sir Anthony seeing Baroness Neville Rolfe and the conduct of your independent investigation?
And knowing me probably better than anyone, I suppose I would have at the time said to myself, look, this is all part of the sort of, the public sector type, how do you handle the minister with this and that? And I would have said, well, if that's a concern and these people have been here for some time and it's to do with these people meeting the minister, that's the chief executive having a view. And it's probably something that I would have said, I'm not, I'm going to focus on what I'm doing, and this isn't something I'm going to make a particularly, big fuss about.
Thank you, that can come down. Ultimately, the person that you asked to conduct the review was Jonathan Swift, QC, assisted by Christopher Knight, another barrister. Why was a decision taken to make this a lawyer-led review rather than something more technical?
I suppose the answer to that is partly around the framing of the review, back to your previous point about responding to the complaints, and partly, I think, because the issues were not exclusively technical, and so what was a QC at the time ended up looking at 4 strands to the problem, as it were.
Were the issues to be considered only legal issues?
Well, I think it's fair to say that out of the Swift review came some recommendations that were not exclusively legal.
Looking at it at the beginning rather than at the end, did you think when you were deciding we're going to get a lawyer to undertake this task, never mind the personality and fact involved, that the issues that required to be examined were exclusively or predominantly legal ones?
I don't think I could comment on whether I had a specific view, but...
Mr. Parker, I'm just trying to pick away a little bit at why a lawyer was chosen.
Okay.
And it could be because there are legal issues to be addressed.
So
I would... Hold on.
Yeah.
Or it could be, I want somebody with a first-class mind who is independent, and it doesn't matter whether or not the issues to be examined are legal.
Yes.
Can you help us?
Yeah, I'll try. I think I had some CVs, and from what I can recall, Jonathan Swift had a very broad range of experience and seemed to be a person who was used to dealing with a number of different settings. And I believe from memory too that Christopher Knight had quite a lot of experience in the sort of, I wouldn't say IT world, but he had done work in that sort of area. So I wouldn't say the QC was in the frame just because he was a lawyer. I would say it was a mixture of things. A lawyer, someone who was used to investigating, and somebody who could, I think, with some help, organise a good sort of report, yeah.
So it was more that they were independent and had the faculties in order properly to investigate the issues, rather than answer a series of legal questions.
I think that's a fair reflection.
Can we look, please, at the instructions to counsel, poll 0011 4270. Page 3, please. These are the instructions to counsel, in fact, initially to advise in consultation on the 8th of October. And so you'd done this quite swiftly, i.e. within a week or so of joining the company.
I got on with the job pretty fast, yeah.
If we just see the authors of the instructions by going to page 15. Foot of the page, we'll see that they are co-authored by Jay McLeod and Roderick Williams. And again, I take it that you wouldn't have seen any issue with lawyers who were themselves directly involved in the underlying events being the ones to instruct Mr. Swift.
I answered that question kind of before. I don't think I'd have a different view.
In your witness statement, I'm just going to read it rather than getting it up on the screen. Paragraph 40, you say, "It seemed to me that Post Office's General Counsel understood the complexities of the task when identifying suitable candidates. Jonathan Swift, QC, was a senior barrister. He had worked as part of the Treasury Counsel team prosecuting complex cases. Did you think he was a criminal barrister?"
I can't recall.
Presumably, if it's in your witness statement, that is your current memory, that he was a member of the Treasury Counsel team that prosecuted cases.
I presume so, yes.
If we go back, please, to page 3, please. There's an introduction. We'll see a reference in paragraph 2 to the letter from Baroness Neville Rolfe asking you to, quote, determine whether any further action is necessary to respond to the concerns about Horizon raised by individuals and MPs. Those concerns include that Post Office's reliance on Horizon has resulted in miscarriages of justice. And then scrolling down, with the assistance of Post Office's General Counsel Jane MacLeod, the chairman considers this to be a request, and this was to form the basis of the review. You'll see the words review in brackets afterwards. Quote, "To review the Post Office's handling of the complaints made by sub-postmasters regarding the alleged flaws in its Horizon electronic point of sale and branch accounting systems, and determine whether the processes designed and implemented by Post Office to understand, investigate and resolve these complaints were reasonable and appropriate." Looking at that now, can you see a shift from the open question in the letter of the 10th of September from Baroness Neville Rolfe to a question that focuses instead on the reasonableness of past processes?
I think with hindsight, it does look that way at the time. And again, I'm sorry to keep reminding you, but there are a lot of things going on at the Post Office, and this response to this request at the time seemed to me to be not unreasonable.
Did you review the instructions at the time?
In what sense? Did I looked...
Did you look at the document we're now looking at?
Oh, I see. Was I aware what the review was about? Yes. Yeah. And was I aware that these were the terms of reference and this was the question that was going to be addressed? Yes.
Is it right that you considered the request in the Baroness Neville Rolfe letter of the 10th of September to mean what is in inverted commas and italics?
So, you know, with hindsight, one's apt to see that there are forces at play here trying to subtly shift the emphasis on things. And at the time, at the beginning of this review, it seemed to me that, and again, I'm probably not a person who is greatly experienced in setting up reviews, that a review with a sort of quite a good general brief was capable of going after quite a lot of different areas. If you look at it, you know, out of that particular group of references, you could see that a good investigator would cover off most of the key points that were at issue. And that was my sort of take. I think because there's been such a terrible subsequent situation, it's very easy to look back and sort of dissect and say, well, could it have been this or could it have been that? As things looked at the time, and perhaps I was a little naive about where the advice was coming from, but I've mentioned, I've talked about this, it didn't look a bad set of terms of, well, not the terms of reference, but it didn't look a bad sort of brief, if you see what I mean.
Thank you. If we just continue paragraph 4, in order to be credible, the review will need to be carried out independently of the team which has been managing Post Office's response to these concerns to date. The chairman therefore requires the assistance of leading counsel to provide him with advice on 1, scope of the review and how this is framed. Over the page 2, it's over 2 pages in fact. Thank you. 2, the process by which the review should be conducted, including what materials should be reviewed and who should be interviewed. And 3, the nature of his final report to the minister. Again, looking at that paragraph there, these seem to be instructions to a barrister to ask him to advise you on scope of the review, how the review should be conducted, and what the report, the nature of the report, finally to the minister should be. Not actually asking him to conduct the review.
Sorry, I'm being a bit dense here, but...
Yes, you could have a set of instructions which say, dear Mr. Swift, we would like you to carry out an independent review. Or you could have a set of instructions which say, can you provide assistance on the scope of a review and how this is framed, the process by which the review is undertaken.
Yes, I understand.
And the scope of his, i.e. your, final report.
I think both. I mean, the way certainly I think we set this up was to say, look, Mr. Swift, we want to conduct a review. We'd like you to conduct it, and I will work with you on the terms of reference. And I think, I'm skipping ahead a little bit, but subsequent to this, we met various people, and as a result of those meetings, the terms of reference were put together.
Can we move forwards, please, to page 15? And under instructions, leading counsels therefore asked to consider instructions prior to meeting Post Office's General Counsel. The aim of the meeting is to settle the review scope, agree a process for conducting, including and reporting on the review within the desired time frame. Then a further meeting at which leading counsel will present the scope and process to the chairman for his consideration. By this time, was it always envisaged that Mr. Swift, as well as advising on the process issues, would himself conduct the review?
I think, and again, I'm looking back 9 years ago, that my starting point on this, as I explained, was that I'm probably not the person to actually conduct the review. Therefore, it was going to be this individual who would actually conduct the review on my behalf. And that made a lot of sense if you think about it, because I had a lot of other things to do, and we could actually get the undivided time and attention of a very well qualified and senior barrister with his assistant to go and do the work, essentially.
Thank you. Sir, it's 11:15, or just coming up to 11:15 now. Can we take the first morning break between now and past?
Yes, of course.
Thank you very much, sir.
Thank you.
Good morning, sir. Can you see and hear us?
Yes, thank you.
Thank you very much, sir. Before we move on, Mr. Parker, to the review report produced by Mr. Swift and Mr. Knight itself, can I deal with an event that happened or may have happened in between the commissioning of the review and the production of the report in February 2016? You've explained to us already your desire, in particular in the light of Baroness Neville-Rolfe's letter of the 10th of September 2015, to find out information about Horizon from a wide range of sources. Do you recall meeting Ron Warmington and Ian Henderson of Second Sight in your office in December 2015?
I know I met them. I don't recall the substance of that meeting, if I'm honest.
Can I just read you what Mr. Warmington has said about it? This is paragraph 85 of his statement. He says, in early December 2015, I received a telephone call from the office of the then relatively new chairman of Post Office, Tim Parker. He invited me to come to his office to help get him up to speed on the Horizon matter. Does that sound likely to be correct?
Likely.
Thank you. I later learned that Baroness Neville-Rolfe had, following a meeting that Ian Henderson and I had had with her, suggested to Mr. Parker that he should meet with us. Again, can you help us whether that is likely to be correct, i.e. the idea of the meet came from Baroness Neville-Rolfe?
Possibly.
He says, on the 15th of December 2015, Ian, that's Ian Henderson, and I went to Mr. Parker's office where we met with him and Jonathan Swift. Do you remember Mr. Swift being there?
Not precisely.
The meeting went on far longer than the pre-booked 1 hour. Mr. Parker having insisted that we stayed longer to answer more questions. Does that trigger any memory?
No, but I think it's probably reflective of the fact that, you know, I wanted to listen to these guys, yeah.
We have got some emails of the 15th of December circulating within Post Office saying they're still in there. They're still in the meeting.
Oh, okay.
It's going on longer than anticipated and you were going to miss your next meeting.
Okay.
Mr. Warmington says, we held nothing back at that meeting. Indeed, Mr. Henderson later characterised it with the words, quote, we gave him both barrels. In practical terms, that meant that we went through with Mr. Parker and Mr. Swift all of the thematic issues that we had covered in our final report back in April 2015. Does that trigger a memory in you that they were particularly forceful in what they said to you, i.e. we gave him both barrels?
I'm sorry not to be of more help, but this is 9 years ago. The answer is no.
He continues, we made it perfectly clear that the rebuttal report that Post Office had immediately issued alongside our final report was utter nonsense, and that were he to be deceived into placing reliance on it, or worse still, endorsing it, the consequences would likely be very dire. Do you remember a meeting of that type, i.e. you had two gentlemen who had been independent investigators coming in and saying words to the effect of the Post Office rebuttal report, i.e. the rebuttal to their final report, ought not to be relied on?
I don't. I think, again, my recollection of this meeting is just not... I just don't have a recollection of it precisely.
Do you recollect a meeting in which it was said that if he, i.e. you, was to place reliance on what the Post Office was saying in its rebuttal report, the likely consequences would be very dire or dire?
I think all I can tell you, because you know the question has been asked 3 times more or less, is that I think Jonathan Swift and I would have listened to what we were told, and he would have taken away a lot of the remarks that were made by Ron and Ian.
If, and I don't think you're in a position to say that what Mr. Warmington has said is incorrect, if he had said those things, what would be the consequences for you?
I think my mindset at the time was we're in the early days of putting together this review. I've heard what these guys have got to say, and we'll take the thing forward. It's not my, I don't think I would have jumped to the conclusion that everything they say is indubitably correct. I think I would have said, well, let's do some more work, which is what actually happened.
I.e., to summarise, you would have seen this as a matter for Mr. Swift to bring into account, rather than for you to take any particular action.
I think that's a slightly false contrast. I think at that stage, bearing in mind that I was going to review the eventual output of Mr. Swift, he certainly would take away the comments of Second Sight, yes.
What would you, therefore, if my suggestion involved a slight false contrast, what were you going to do with what you had been told?
I think my mindset at that point was to allow Mr. Swift to do the work and produce the report. I don't think I took out of that meeting, because actually, as far as I'm aware, I didn't do anything immediately. I don't think I took out of this meeting, I've heard these people, I'm about to go out and do something. Let's do the report and let's see where it goes.
I.e., the meeting was held in the context of somebody undertaking a review, and the person undertaking the review ought to pay regard to what was said, rather than you do anything independently.
I mean, honestly, I think this is a bit of a hindsight characterization of a meeting at the time where I was quite early still in the business and would have just been doing a lot of listening. So I'm not sure out of it, I just moved on with the review, yeah.
But it can't be every day that you have independent investigators or consultants, management consultants or forensic accountants come in, and if they're correct in what they say, tell you as a chairman that you shouldn't be relying on the public-facing document that your executive have put out.
No, and I think it's fair to say that the Swift review, when it came to be put together, certainly did not take, if you like, the House view as the only version of events. I think quite a lot of the comments of Second Sight were incorporated into the review itself.
Let's look at the review itself. Poll 406355. I'm not going to go through every paragraph of it, not least of which it's 66 pages long, and that wouldn't be productive. If we can look just a little bit further down, we'll see the date of the 8th of February 2016. And if we go forwards to page 2 and just pan out a little bit, we will see the structure, the overall structure of the report. After some introductions and passages about the scope of the report, it's divided into chapters concerning Post Office, sub-postmasters and the Horizon system, the complaints themselves, the criminal prosecutions, the Horizon system, support provided to sub-postmasters, investigations, i.e. past scheme investigations, and a summary of recommendations. If we go forward to page 3, please. And if we just look at the end of paragraph 2, four lines up, these matters have been the subject of consideration and investigation by and on behalf of Post Office on a number of occasions. The purpose of this review is to consider whether any further action could now reasonably be taken by Post Office to address the matters raised by the sub-postmasters. Paragraph 3, 5 lines up from the bottom. The legal department of Post Office has been the source of most of the information provided to us, but we have determined what information should be provided. When the review was being undertaken, did you have a running commentary essentially on it, or did you set the terms of reference as we've seen and then wait for the review to report?
I think it, I mean, again, without wanting to deliver a definitive view, I think there was a sort of ongoing discussion. I don't think it was a sort of, here's the terms of review, give me a ring in 5 months' time or whatever. No, I think there was some ongoing discussion.
You certainly received a draft report in January.
Did, yeah, in January, yeah.
Did you know that the legal department was the source of most of the information provided to Messrs Swift and Knight?
I think I probably did, yeah.
If we go over the page, please. The purpose of the review was originally described in the following terms. And then we see the quote from the briefing paper we read earlier. We've been guided by this, but we've concentrated on whether any further action is reasonable and necessary in respect of these issues. This has highlighted 2 principal questions. What has been done in the 2010 to 15 period? If there are any gaps in the work done, is there further action that can be that can reasonably now be taken? Over the page, please, and look at paragraph 10. Having set out in summary the documentation that the authors have reviewed, they set out in paragraph 10 those with whom they met. Lord Arbuthnot, Second Sight, Deloitte, Fujitsu, Ajlavand and Bogard, Mr. Seller, Miss Dickinson, and Miss Hailstones and Miss Alexander. And then if we go forwards, please, to getting more to the substance, to page 34. You can see on pages 34 and 35 the author's view on one of the issues, namely the sufficiency of evidence to bring charges of theft. I'm just going to read these passages. The allegation, as we understand it, is that post officers too readily brought a charge of theft, which is said to be more serious than false accounting, with the aim or effect that the sub-postmaster is pressurised into pleading guilty to false accounting in the hope that the theft charge is dropped, and because a theft charge would more readily enable Post Office to recover its losses. We understand there are approximately 18 scheme cases in which this or something similar occurred. We've read the full trial transcript of Seaman Misra, in which a jury convicted the defendant of theft following a guilty plea to false accounting. Whether Post Office had sufficient evidence to bring a charge of theft alongside charges of false accounting is an accusation raised by a number of scheme applicants, as well as Lord Arbuthnot, also a matter raised by Second Sight. At 102, we're aware that the suggestion has gained particular traction in scheme case MO35. In this case, certain documents in the prosecution file indicated that Post Office investigators could not find evidence of theft. This is the case of Josephine Hamilton, I should say. Although there was clear evidence of false accounting, but theft was nonetheless charged. We've seen these documents and have noted the absence of clear documented rationale for charging theft over the page. We note that Brian Altman's advice of the 8th of March that it is not a helpful question to ask whether theft or false accounting are offences of equal seriousness, both being dishonesty offences with a maximum sentence of 7 years imprisonment, because the seriousness is dependent on the nature of the specific allegation rather than the charge per se. We entirely accept the decision to plead guilty is a matter for the defendant alone. Any concerns they have about the legal advice they received at the time is a matter only the defendant can pursue and is not the responsibility of Post Office. It's always open to the defendant to challenge the sufficiency of evidence disclosed to him or her and seek to have that charge dismissed. Post Office's position is that its prosecutorial decisions are always taken in accordance with the code, which requires that there be sufficient evidence to provide a realistic prospect of conviction, and the prosecution must be in the public interest. Post Office has referred us to the Cartwright-King disclosure review exercise, noting that Cartwright-King also expressed views in their advice as to whether Post Office should oppose any appeal brought, suggesting that they must therefore have considered the evidence involved. Post Office has also explained to us that because of these points, and because any review would be carried out with the benefit of hindsight, it would not be an appropriate course of action to review now the prosecution files to reconsider the sufficiency of evidence issue. And 106, we do not agree. We've reached the view that this issue is one of real importance to the reputation of Post Office and is something which can feasibly and reasonably be addressed now. It's clear it's not an exercise which has been carried out so far. Cartwright-King were not asked to consider the sufficiency of the evidence when undertaking their disclosure review. Skipping a paragraph, the allegation that Post Office has effectively bullied sub-postmasters into pleading guilty to offences by unjustifiably overloading the charge sheet is a stain on the character of the business. Moreover, it's not impossible that a sub-postmaster would have felt pressurised into pleading guilty to false accounting, believing it to be less serious when they might not otherwise have done so. The phenomenon of false confessions is well known. I'm going to stop reading there. That's quite strong language, isn't it?
Quite strong, yeah.
Is this an example of what you mentioned, I think, in passing earlier, that the review did not universally take on board the Post Office's position?
I think that's right. And I think in a way, because, as we know, the aftermath wasn't necessarily satisfactory, but at the time, it was a good, for me, a confirmation that to have a qualified barrister look at these things produced a pretty good analysis of the issue and its impact, and as if we go further, obviously recommendations about what to do about it.
You said there that the aftermath wasn't necessarily satisfactory, we know.
You know, Swift, in my view, was quite a good report and contained quite a lot of good material. And as the litigation unfolded, as we will discover a few months down the line, effectively Swift was stopped and repurposed. So this component of Swift actually, you know, again, the result with hindsight might not have been satisfactory because its scope of investigation was limited, but, you know, Alman did his review and produced his report. So, you know, from the perspective of here's the problem, which is, you know, charging theft potentially with the pressure to get people to own up to false accounting. I think Swift more or less got that, but it didn't, you know, again, it translated into the Alman work. So this component, I think, again, moved the thing forward as you would want it to be moved forward.
Can we turn to the recommendations of Mr. Swift's report? And I'm not going to, in the way I've just done there, track the foundation for the recommendation into the recommendation on every occasion. That was just one example.
Yeah, yeah.
Page 38 then, please. The recommendations arising from that section of the report are, one, in bold, legal advice be sought from counsel as to whether the decision to charge a sub-postmaster with theft and false accounting excuse me, could undermine the safety of any conviction for false accounting where A, the conviction was on the basis of a guilty plea, following which and or in return for which the theft charge was dropped, and B, there had not been a sufficient evidential basis to bring the theft charge. And 2, if such a conviction could be undermined in those circumstances, that counsel review the prosecution file in such cases to establish whether, applying the facts and law applicable at the relevant time, there was a sufficient evidential basis to conclude that a conviction for theft was a realistic prospect such that the charge was properly brought. I think you'd agree they are sensible recommendations arising directly from the passages that we've just read.
Yeah, yeah.
Can we turn then to page 43? At the foot of the page. 125. The Horizon system does occasionally suffer from bugs, which have caused losses in some branches. Those bugs have been generic in the sense that they have the potential to affect any branch, depending on how it is structured. It's often the case that those bugs are identified when the sub-postmaster draws the attention of Post Office and Fujitsu to an odd situation which she cannot explain and which appears to have caused the discrepancy. We were told by Post Office that when carrying out their investigations into scheme cases, investigators were looking out for unusual or unexplained patterns of transactions which might have required further technical examination by Fujitsu to confirm whether there was a wider bug. Post Office told us that no instance arose and Fujitsu were not asked to look at the records in any case. Fujitsu confirmed to us they did not carry out any analysis of scheme records. We consider that the possibility of an alternative approach to the transaction analysis would have provided greater certainty that there was no bug which had affected some of the scheme branches. We take this view because Post Office's approach was necessarily bottom-up in the sense that it started from and focused on the specific circumstances of the branch, looking at the transaction logs where necessary to review a particular complaint, be it general or specific, skipping over. A different but complementary approach would have been a top-down analysis of the transaction logs of the scheme branches undertaken by Fujitsu or an independent qualified party to search for patterns of unusual behaviour in individual branches and across branches on a purely data-driven analytical basis, which might suggest a wider problem, which could then be cross-referenced with the branch fact-specific work carried out by Post Office. In our meeting with Deloitte, it was confirmed that this type of exercise was something they would have expected carried out across the relevant data set, including non-scheme branches as a control to look for oddities or reconciliation errors. We're mindful that external organisations are more likely to suggest possible sources of work they could carry out, but the suggestion aligns with our own view, which is at least potentially useful to rule out more comprehensive the possibility of a system bug affecting some scheme cases. Again, a series of observations or views that you would consider reasonable?
I think I probably did at the time, yep.
If we go forward to 53. I should have stopped off on the way at 51, at paragraph 145, just in passing. It seemed to us that the Deloitte documents in particular pose real issues for Post Office. First, both the existence of the balancing transaction capability and the wider ability of Fujitsu to fake digital signatures are contrary to the assurances provided by Fujitsu and Post Office about the functionality of the Horizon system. Fujitsu's comment we quote above seems to be simply incorrect, and Post Office's Westminster Hall response is incomplete. To the extent that Post Office has sought to contend that branch data cannot be remotely amended because a balancing transaction does not amend existing transactions but add a new one, we do not consider this as a full picture of Horizon's functionality. The reality is a balancing transaction is a remotely introduced addition to branch records, added without the need for acceptance by the sub-postmaster, which affects the branch's balance. That's its express purpose. Post Office has always known about the balancing transaction capability, though the Deloitte report suggests the digital signature issue is something contrary to Post Office's understanding. Just stopping there as I went. When you received the report, did you know about the remote access issue?
No, I don't think so. I can't be sure, but I don't think I did.
Did you know that there was a concern that either the Post Office and or Fujitsu had a facility remotely to access branches?
I don't think I did. You know, the remote access issue, of course, has been quite a big element of this whole set of problems. And I think my take on it was, in theory, there is a remote access problem, and if we, you know, we'll get to the recommendations in a moment. Let's see and let's try and understand this theoretical ability. How practical is it, in fact, to remotely access accounts? And that was, you know, what I took away from this, I suppose.
Did you take away from the fact that Fujitsu and Post Office's public-facing comments had been incorrect and incomplete?
Yeah, that's something. I've looked back at this, and I suppose my reaction at the time was essentially too swift, and we'll get onto the legal privilege thing in a minute, was, you know, this is a report, there are some recommendations, let's actually get to the recommendations, and then my hope and intention was to, you know, have the outputs of the report discussed. Now, we didn't get there, much to my regret, and I think I was probably a little optimistic about how quickly we could get on top of some of these issues and then properly correct the issue, I suppose. But, you know, it was something I was aware of. And with hindsight, perhaps we should have jumped up immediately and said, look, you know, there is a theoretical possibility of remote access. And I was assuming, as it turned out probably quite wrongly, that we could do the work on Swift and then say, yes, there is remote access and it is theoretically possible, but practically it either is likely, less likely, or very unlikely. That was, I think, where I got to with it.
Where did you get information from that remote access was only theoretically possible?
I think that's what was said here, essentially. That was what I took away from it anyway.
In any event, let's turn to the recommendations on this part of the report by looking at page 53. We recommend 3, Post Office consider instructing a suitably qualified party to carry out an analysis of relevant transaction logs for branches within the scheme to confirm, insofar as is possible, whether any bugs in the system are revealed by the data set which cause discrepancies in the accounting position of any of those branches. 4, Post Office instruct a suitably qualified party to carry out a full review of the use of balancing transactions throughout the lifetime of the Horizon system, insofar as is possible, independently to confirm from Horizon system records the number and circumstances of their use. 5, Post Office instructs a suitably qualified expert to carry out a full review of the controls over and use of the capability of authorized Fujitsu personnel to create, amend, or delete baskets within the sealed audit store throughout the lifetime of the Horizon system, insofar as is possible. Those 2 recommendations, you'll see, are speaking about the lifetime of the Horizon system. Did you understand them at the time to mean literally since Legacy Horizon had started, i.e. about 2000?
I can't tell you. Of course, with hindsight, the lifetime thing actually gets to be quite critical, because it turns out that most of the real issues that people experienced were with Legacy Horizon. But I'm not sure that really That really came through to me as a big thing at the time. Yeah.
Post Office seeks specialist legal advice from external counsel as to whether the Deloitte reports or the information within them concerning balancing transactions and Fujitsu's ability to delete and amend data in the audit store should be disclosed to the defendants of criminal prosecutions brought by Post Office. This advice should also address whether disclosure should be made, if it's not been made, to the CCRC. Again, upon reading this, you wouldn't have had any reason to reject the recommendations.
No.
They seem reasonable and sensible.
They seem reasonable and sensible.
And they're grounded in the body of the text that preceded them.
I mean, absolutely, yeah.
If we go forwards, please, to 64. And paragraph 173, there's one issue which potentially relates directly to the scheme cases, but which has not, so far as we're aware, been the subject of any specific analysis. That issue was the one raised by Second Sight in their Part 2 report, the reference is given, and relates to the handling by Post Office of unmatched credit balances in its own suspense account or similarly named account in respect of third-party clients, such as Santander or Bank of Ireland. The point Second Sight raise is that where there are significant sums in unmatched balances, it is possible that at least some of that money would reflect uncorrected transaction discrepancies in particular branches. We consider that this is logically possible and is at least the least worthy of express investigation and clarification. Accordingly, we recommend that Post Office commission forensic accountants to review the unmatched balances in Post Office's general suspense account to explain the relationship or lack thereof with branch discrepancies and the extent to which those balances can be attributed to and repaid to specific branches. Again, does that fall within the same category that we just discussed? Reasonable and grounded in some...
Reasonable and grounded, I agree.
There's one that I've missed out, 7, I think. If we go forward to page 66. Number 7, Post Office should cross-reference specific complaints about misleading advice from MBSC call handlers with the possible employees who provided that advice and consider their personnel files where available for evidence as to the likelihood that the complaint may be well-founded. So if we just go back to 65 and pan out, the recommendations 1 to 5 are collected together in a summary, and then over the page we see 6, 7 and 8 collected together. Overall, would you agree that there was a wide range of work that required to be done arising from the Swift review?
Yes, I think we were talking earlier about, the terms of reference and whether it was correctly structured. But actually, I feel with hindsight, again, that Swift was not a perfect piece of work, but it wasn't a bad piece of work, and it yielded some good recommendations.
Would you agree that the review raised significant reputational issues for the Post Office in the light of what it uncovered and the recommendations that it made?
I think there were some issues that definitely needed addressing pretty urgently.
And what about my question, Mr. Parker?
Yeah, no, I think that's a fair, these are all matters with some reputational impact potentially.
Significant reputational issues for Post Office was how I formulated it, if this was publicly disclosed.
Yeah, I'm not going to argue about the language. These are important matters, yeah.
Sometimes it's important, though, the language.
Yes, no, I think you're absolutely right. Let's say reputational issues, matters.
You had a decision to make, that can come down, thank you, as to with whom the report should be shared, correct?
Yes.
When the report landed on your desk, in your inbox, more likely, did you have a view as to with whom it should be shared, if anyone?
That's a very interesting question. So to go back into the history of this thing, it was always envisaged that the Swift review would be legally privileged. And I think that was explained. I haven't got the papers to hand, but somehow it was envisaged that it would be a report from a QC at the time, and it would be legally privileged.
Just stopping there.
Yeah.
The report on its face is not marked as privileged, is it?
No.
And the report does not say that it's been provided for the purpose of any ongoing litigation.
It doesn't.
It doesn't say that it was provided for the purposes of obtaining legal advice, does it?
No, but whatever was actually on the report, and I'm not looking at whether it's got. I understood and was advised by General Counsel that it should be legally privileged, and I believe that was understood also by civil servants at the time as well. I may be wrong, but generally it was understood that this would be a piece of legally privileged work with a view, once the recommendations had been carried forward, to being shared more widely. That was my understanding of it.
You said that there was an assumption. Who held that assumption?
When you say...
An assumption that the report would be legally privileged was one of the things that you said. Who held that assumption?
That's quite an interesting question. And I'm not sure I've got a ready answer to it. All I can tell you is that my recollection, and certainly what I understood, was that the report would be legally privileged. That was the advice that I received at the time.
Was that advice orally or in writing?
I can't confirm whether it was oral or in writing, but I certainly understood that to be the case.
Who gave you the advice?
The General Counsel.
J. McLeod?
Yes.
J. McLeod, in her witness statement, no need to turn it up, it's WITN 1001-0100, at page 100, paragraph 184, says, I'm aware from open source material that Tim Parker has said that I'd advised him not to brief the board on grounds of confidentiality and privileged. My recollection is different from Mr. Parker's, although I agree that I discussed privileged and confidentiality when I met him. My recollection is that the senior independent director, Mr. McCall, asked a question at a board meeting as to whether the board would be briefed on the findings of the chairman's review. I believe that as a result of that question, I provided an oral briefing to the board as to the scope and findings of the chairman's review, as well as a summary of the further work being undertaken following the chairman's review. Although I've not seen any documents which indicate that the full report was circulated to the board, my recollection is that I advised the board that the full report was available on request.
Indeed, that's what she put into her witness statement. And I can only say that I know which particular document it's in, but she advised that the report should be 4 copies, I think, none saved to a hard disk or whatever. And it was clear, I'm sure, she told me, and my recollection, I don't think is wrong, that this was going to be a legally privileged report, and that's why it was restricted to 4 copies only that were held within the legal department. And her comment, I mean, the other point to make, I suppose, is, because this is of interest, is that there was no intention to hide the report as such. People knew about the report, but it was a legally privileged document. And again, it's one of my regrets is that I got that advice and I took it, and that's essentially how the report was conceived.
So it was advice from the General Counsel, Jane McLeod, directly to you?
Yes,
the-
and that sort of privilege...
Sorry,
yes, I beg your pardon.
The report, the Swift report, was a legally privileged document.
That was certainly my understanding at the time, and I believe in communications with the UKGI, it was also made clear...
We're going to come to that in a moment.
Yeah.
For you, what were the consequences of being advised that the report enjoyed legal privilege?
So...
What did that mean for you?
Yeah, so look, here I am. I've had this report commissioned, right? I've got no history of, I wanted to get some kind of result from it. But then I get this advice. And as I understood it at the time, the report would be legally privileged. The GC and her team, with others, would take forward the recommendations. And when the recommendations were completed, the outputs would then be shared. That was my sort of view, and that's what I expected to happen.
The fact that you were advised that the report was legally privileged, what did you understand as to who that prevented you from sharing the report with?
Yeah, I think that, again, this is one of the slightly unsatisfactory elements of the whole thing, is that I felt, erroneously probably it turns out, that legally privileged or legal privileged meant that the report effectively was circumscribed to only the people who were involved in the legal process.
Was that something that you were advised by Miss McLeod, or was that something which you assumed on the basis of being told the report is privileged?
I can't tell you for sure, but I think the fact that I was told that the report should only be confined to 4 copies, I certainly took away from that legal privilege implied that it was a report that would be held in a very tightly knit group of people. And these were the 4 people, and they were all people who worked in the GC's department.
In practice, did that understanding, I'll call it, that you reached, prevent effective discussion from taking place at the board of the Post Office if members of the board could not see the report?
So I think, whilst being aware of the report, I felt it certainly did, yeah. I mean, my view at the time was that, and perhaps this was somewhat naive, that the recommendations would come out pretty quickly. And we would be able to talk about, the report as completed, but that didn't happen, unfortunately.
Did you understand from what Jane McLeod advised you that you were prevented from sharing the report with other board members?
I think that was my understanding, yes.
What did you understand, if you did understand it, to be the difficulty in sharing a report with other board members who themselves would owe a duty of confidentiality and confidence to the company?
I thought, and again, perhaps it betokens a certain lack of experience in this area, that legal privilege meant a restriction on the circulation of the report. And with, what I've read subsequently, was the report meant for me personally, and was it going to be legally privileged for me personally? Could we have shared it? I wish we had, in a way, and I think a suitably redacted version of that was the issue, perhaps could have been shared. It's just one of those things that at the time I was advised and I took the advice. It's one of the unfortunate aspects to all of this is the extent to which perhaps advice taken from specialists turned out to be something that might have been tested or reviewed in a different way.
I'll ask you the direct question. Did Ms. McLeod tell you that the fact that the report enjoyed privilege prevent you from disclosing it to the board?
That was my understanding.
Yes, did she advise you directly?
I can't confirm one way or another. All I can do is look back and say, look, what possible motive would I have had at the time from hiding this report from my fellow board members, other than receiving advice that I shouldn't share it with my fellow board members? Bear in mind, I had no axe to grind on this. I had no any vested interest in trying to protect the post office or whatever it had done. It was simply the advice I received, and I followed it.
As part of the quote from Ms McLeod's statement that I read you, she said, my recollection is I advised the board that the full report was available on request. Were you present at any board meeting at which they were told, if you want the report, you only have to ask?
Well, I presume that if that's what Jane McLeod has said, and she attended board meetings, and I can only think of one board meeting that I missed in the whole of my time at the post office, I probably would have been there, yes.
Can you recall that being said? It's not reflected in any of the minutes.
I can't.
What was your understanding as to the fact that the report was said to enjoy legal privilege insofar as distribution of a copy of the report or sharing the contents of the report with the minister or government was?
I think that was a similar concern, and I should say that the legal privilege thing, I'm now beginning to recollect it a little bit more, was around the freedom of information mechanism. So we had a UKGI board member, and one of the concerns was that things that were distributed that got into the hands of essentially bay civil servants in one form or another potentially could be disclosed as part of a freedom of information request. And that whole sort of consideration coloured the discussion around Swift and how it was explained and how it was kind of discussed at the time.
Can we look, please, at poll 00103108? An email before the final report is available. It's dated the 22nd of January 2016 between Jane McLeod and you. Tim, following our call with Jonathan Swift today and ahead of your meeting with Baroness Neville-Rolfe on Tuesday, I've summarised our progress. I'm going to skip over for the moment how we take forward his recommendations and just look at briefing to the Minister. We scroll down. We also discussed with Jonathan whether there were any limitations from his perspective on the content of your briefing to the Minister. Jonathan confirmed that there were no limitations from his perspective, although he noted that if a physical or electronic copy were provided, this could result in a loss of legal privilege in connection with the document, recognising that in the absence of privilege, the report could be disclosable under a freedom of information request. Is that what you were just referring to?
Yeah.
Accordingly, our recommendation is that you provide a verbal briefing to the Minister that in response to the question, quote, was there anything further that Post Office should do? Jonathan has made a series of recommendations which have been accepted by the Post Office. 2, these recommendations will be followed up as soon as possible. 3, in relation to 2 of the IT-related recommendations, the scope of work required to discharge the recommendation is uncertain, and we will therefore commission work to determine whether the work is feasible. And 4, we will provide you with regular updates on progress of this work, and you will therefore be able to provide updates to the Minister in future briefings. Once the work is completed, we will need to consider whether the Minister requires anything in writing from you and whether any such document would be made publicly available. This is a reflection of an a meeting that I think Jane McLeod had, or a call that Jane McLeod had with Jonathan Swift, and advice as to how you are to brief the minister, correct?
Looks like it, doesn't it? Yeah.
The sentence, Jonathan confirmed there were no limitations from his perspective on the content of the briefing. But if a physical or electronic copy was provided, this could result in the loss of legal privilege. Did you understand that a choice fell to be made from that advice?
Yes, I think I probably, to a certain extent, well, actually looking at it, I think what I understood was that something that was physical, if things were put down and written physically or typed physically, that could be subject to a loss of legal privilege. And I suppose perhaps from that I sort of conflated, what could I say to the minister? I don't, did that mean I could only say to her what was in a piece of paper? I don't know.
More specifically, did you understand that you had a choice to make? I can either brief her orally about along the lines set out in those 4 bullet points, or I can give her a copy of the report, and that may result in a loss of privilege.
My recollection, for what it's worth, is that I think we all, including the minister's civil servants, were kind of not assuming, but felt that this was going to be a document that had legal privilege. So with hindsight, you're right, there was potentially a decision to be made, but we fell into it's legally privileged, so we'll do the verbal briefing instead.
Did you realise at the time that there was a choice?
I don't think so, if I'm honest.
I.e. the fact that it was said to be legally privileged dictated the outcome or the treatment?
I'm afraid a lot flowed from that. It was a legally privileged document, therefore we had to speak around it, and how it was summarised on paper needed to be thought about, yes.
Can I ask you, Mr. Parker, at the time, was there any discussion about who enjoyed the privilege, if privilege existed?
So when I can't, no.
Because it strikes me, at least, and I'm not pretending I'm an authority on this, that there are only 2 possibilities, aren't there? Either you personally enjoyed the privilege, or Post Office Ltd enjoyed it.
Again, I have to answer you honestly and say my knowledge of legal privilege at the time wasn't sufficiently sophisticated, is probably the best description I can give it, to differentiate between was it privilege to me or was it privilege to Post Office. I just kind of took legal privilege to mean it was kind of privileged, like.
Yeah, and I'm not really asking you to address your mind to the distinction, as opposed to whether there was any discussion about that distinction.
No, not that I can recall.
And finally, you'll obviously know from this inquiry that it's possible for a party who enjoys legal privilege to waive that privilege if someone asks them to, like I asked the Post Office in this inquiry. Did anybody, either on the Paul board or in government or civil servants, ask you to waive legal privilege if this document was indeed privileged?
I can't confirm that because I can't remember is the honest answer to that question. But the fact that I can only say that nothing happened in that regard, and it doesn't stick in my mind as a topic that was raised at the time.
So on the state of the evidence at the moment, and things may change, obviously, because we're going to hear from people who may have a view of this. But at the moment, there's nothing to suggest that anyone asked that there be a waiver of privilege.
From my recollection, the answer to that's no.
Fine.
And a related question to that, Mr. Parker, did you inform Baroness Neville Rolfe, the Minister, or anyone else within the department or SHEEX that you wouldn't be providing government with a copy of the report because that was on the basis of legal advice received, that doing so could result in a loss of privilege? So not only was that the reason
I
for
understand.
acting, that was the explanation given.
Yeah. So all I can tell you is that I'm not sure what the Minister was told exactly, but I have this report and I have absolutely no reason not to show this to people. I've got no vested interest, and so I conclude, looking back, that I must have felt that the advice that I'd been given was not to share the report physically with the Minister.
But you've got no recollection whether that was explained in terms?
I haven't, no.
Thank you. So it's 25 past now. Can we take the second morning break until 25 to?
Yes, of course. Yes, of course.
Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Thank you. Mr. Parker, can we just look at some documents that were created years later
Yeah.
in 2020, which speak to the issues that we're currently discussing? Starting by looking at UKGI 301-1785. This is an email from Tom Cooper, who I think you'll know, to Sarah Mumby, who I also think you'll know. It's dated Sunday, the 19th of April 2020. It says the information attached contains legally privileged information. Do not forward. Ahead of our meeting to discuss the Post Office, which I hope is happening this week, I'm attaching the key documents for us to consider. If we just scroll down. The following documents are attached: copy of the QC's report. I suggest you read the recommendations at the back, and copy of Tim Parker's letter to the Minister, which followed delivery of the QC's report. We're going to look at that in a moment. So there, and there was another document which is redacted. So if we scroll up, please. The subject of the meeting is the reporting to ministers and governance in the company that took place after Tim Parker was appointed chairman. So there's a meeting in 2020 about the reporting by you and others to ministers and governance in the company back in 2015, essentially. The minister at the time was Baroness Neville Rolfe, who asked him to appoint a QC to review the handling of the Horizon IT dispute. That's not entirely accurate, is it? She didn't ask you to appoint a QC.
No, that's not entirely accurate. You're right.
And satisfy himself that issues have been handled appropriately. That's more accurate.
That's more accurate.
Yeah. Then scroll down. Following documents are attached. It says in the penultimate paragraph, in addition to the above, it seems that neither the QC's report nor the existence or conclusions of the follow-up work commissioned to deal with the QC's report were known to the board of the company or to Bayes. Is that accurate on your understanding?
Not entirely, I don't think. I think in relation to the board, although they didn't see a copy of the Swift report, I'm pretty sure that Paula Vennells summarised the recommendations.
We're going to come to that in a moment.
I think so. And I think also that, as Jane McLeod said in her evidence, she provided a briefing. So I think it's not quite true to say they were unaware of the existence or the conclusions of the board. And I would say Bayes certainly knew about the report, I think. Obviously they didn't see it, but I think they were aware of it, yes.
The word existence seems to apply to the follow-up work rather than the report itself.
Nor the existence or conclusions
of the follow-up work.
Of the follow-up work.
So it's not talking.
Oh, I see. I see your point. I understand the point you're making now.
On your understanding,
yeah. Yeah. So I think that was part of the consequences of the report being stopped effectively later in May or June, and the work being taken forward under the aegis of the General Counsel in the context of the litigation.
Thank you. Can we look at UKGI 301-2703? This is seemingly a meeting later in the year, this email refers to, again circulating within UKGI on the 16th of September 2020. It's not a communication to you, but it's about you. And I want to ask you some questions. Ahead of our call this afternoon, this is just to update you, that Ken McCall, the Senior Independent Director, I think the SID is that correct?
Yeah, the SID, yeah. Yeah.
has confirmed that having spoken to other members of the board as he deemed appropriate, he does not think it is appropriate to take any action in relation to Tim Parker's decision-making around the QC's review in 2015 of Pole's handling of the Horizon complaints. His rationale is the same as reported previously. Ken, that's Ken McCall, believes Tim, you, made a significant error of judgment in accepting legal advice that the QC's report and, as a consequence, the follow-up work should not be shared with the board. Firstly, was that put to you that you had made a significant error of judgment in accepting advice that the report and therefore the follow-up work should not be shared with the board?
At what point in time?
At any point in time.
I'm not entirely sure anybody has put this point to me, actually. I think certainly when Tom Cooper became aware of it, I think he probably had a discussion with Ken McCall, and this was the output of the discussion. But I can't recall anybody coming up to me in the corridor and saying, hey, Tim, you know, looking back 9 years, you made a bit of a decision that was wrong. We think it's a significant error of judgment. Are you just about scrape by and cling on to your job here? No, nobody said that.
Never mind corridors. Was there anything more formal?
No.
And it would have been 5 years, not 9.
5 years.
Was there anything more formal in which, by which you were chastised, essentially,
Not that I
for
can,
your decision?
Not that I can recall, but sometimes unpleasant events are put out of one's mind. So I might have got this wrong, but I don't think so.
That's a different issue, whether you got it wrong.
Well, I might have got it wrong in terms of do I remember it?
I
That's
see.
the point I'm making, yeah.
The email continues. He has some sympathy, that's Ken McCall, has some sympathy with the fact that you would have had to take a very strong position against the legal advice at the initial stage of his tenure to achieve a different outcome. Overall, Ken McCall's view is that you have been a strong force for positive change at the company while you have been chairman, and it would be unfair and disproportionate to take action over this specific issue. I haven't asked him to put any of this in writing or come in to meet ministers or officials to discuss. This is an option if the decision is to take this further at our call. Was that explained to you, that an option was to take formal action against you, but on balance a decision was taken not to do so because this was early in your tenure? You would have had to have taken a strong position to go against legal advice that you received, and that overall you have been a positive force for change?
The answer is, and again, I'm searching my recollection here because I don't want to give you an answer that isn't true. I honestly can't remember having a formal discussion about this. Can I say something about this? Because
yeah, sure.
I do feel it's quite a fine hindsight judgment to have made that this is a significant error of judgment. I think that Swift was something which produced some good consequences. The first recommendation, the second recommendation, the seventh recommendation, and ultimately the eighth recommendation were followed through. The work, which no doubt we will discuss later in Bramble, was also substantially followed through and informed the Post Office's litigation. And so I fully accept that had Swift been discussed at the board, it may have led to a different approach to the litigation. But I should say that it remains my view to today that once the litigation has started, or had started, and although I think we'll see it wasn't necessarily handled in the best and cooperative manner. The litigation, the GLO, ultimately proved to be a comprehensive, what's the best word I can find? A comprehensive settlement of a lot of very complex issues. And I have replayed in my mind, Mr. Swift, what might have happened had we not, had the GLO and everyone had read Swift and said, oh, there's a problem. The problem is that, our contract with the sub-postmasters is completely wrong. So we better tear it all up. And somebody had said, oh, by the way, the computer system's got a lot of bugs and it's unreliable. And I've replayed in my mind exactly what might have happened then, which is that we would have gone to our paymasters, the government, and said, we've got a slight problem. Our contract that we've had for a long time is not fair. We've got another problem, which is that our computer system, certainly legacy Horizon, anecdotally, it's full of bugs. Or we got somebody to independently apparently suggest that. My view is that the debate that would have ensued between, so what is a reliable system and what are the consequences and therefore what compensation is due, and the contract isn't fair, and so we'll go through all of that. I do believe whatever the impediments placed in its way, and maybe it could have been handled a lot better, but a judge-determined settlement of all these issues has and should have resulted already in a comprehensive compensation settlement for all affected. And the result of all this should have been, in my view, that this whole thing has been completely wrong and a very large amount of money is payable to all concerned. And unfortunately, it's just taken, following the ultimate settlement in the trials, it's just taken far too long. Sorry to give you an extensive extempore on all of that, but you can imagine someone who sat in this seat looks back and says, how could it have been better? How could it have been different? How could it have been faster?
Are you saying by that answer that it needed a group of brave and determined sub-postmasters to hold the post office to account by bringing the post office before a court, and that the post office was incapable of doing it itself?
I'm aware that the counter-argument to all of this is that there should, it should have been something that was resolved inside the post office without the recourse to the litigation. And with hindsight, the postmasters, Sir Alan Bates, should never have been required to mount a group litigation order. I understand that. All I'm saying is that once it was in train, had it been managed a bit better, then a lot of complex issues might have been determined without the delay and without the cost. But a judge review of all these issues, I still think one way or another was the right way to get, an outcome in the end, yes.
So you are saying that irrespective of the things that we're going through now, even if things had been done differently, it would have always have taken a judge to hold the post office to account?
No, I think what I'm saying is that a judge, of course, holding to account, you're absolutely right, that the result of any judgment would hold the post office to account. All I'm saying is that it would have been, in my view, practically speaking, although I can perfectly accept this isn't the right outcome, but given where we got to, trying to see if this could have been managed internally to the same result, I'm not sure.
Can we move forwards, please, to UKGI 00019313? This appears to be, Mr. Parker, the culmination of those meetings that we've just read about happening in the emails, discussion over what to do with you about your conduct in 2015, 2016 concerning the Swift review. It's a letter directly to you from Sarah Mumby, then Permanent Secretary at Bayes. Dear Tim, as part of our preparation for the Bayes Select Committee hearing, which has been scheduled for March, we received from the Post Office a copy of the report prepared by Jonathan Swift that was commissioned by you at Baroness Neville Rolfe's request after your appointment as chair in 2015. We understand from the work done recently by the company and its advisors to look at the history of Horizon that the findings and recommendations by Jonathan Swift were not shared with the Post Office Board, the rest of the Post Office Board. We understand that you were advised at the time by the Post Office's General Counsel that for reasons of confidentiality and preserving legal privilege in the circulation of the report should be strictly controlled. That sentence there accords with what you've told us today, doesn't it?
I think it does, yeah.
Nevertheless, given the background of parliamentary interest, the fact that your review was commissioned by the minister responsible for the Post Office, and the potential significance of the recommendations made by Jonathan Swift, we consider it was a mistake not to have ensured that the whole board had an opportunity to see and discuss the detail of its findings and agree what any next step should be. With hindsight, this information should have been seen by the board, and we're disappointed that it wasn't. You mentioned earlier about being taken aside in a corridor and being essentially chastised or told off. This is the written equivalent to that, isn't it?
Yes, I think it definitely is, yeah.
As a rule, we think it's quite difficult to envisage any circumstances where issues of legal privilege or confidentiality should prevent relevant information being shared with a company's board. But you won't need us to remind you of the importance of effective corporate governance, and that the role of the board is to ensure the company's prosperity by collectively directing the company's affairs while meeting the appropriate interests of its shareholders and relevant stakeholders. And then there's a counterbalancing point or paragraph. Finally, we also recognise that while you've been chair and under Nick Reed's new leadership, the board has instigated and directed a fundamentally different approach to handling the grievances brought by postmasters affected by Horizon, as well as initiating significant changes to the organisation, processes and culture of the organisation. These are to be welcome, and we continue to encourage the company to act quickly and decisively to do what it can to remedy the remaining issues arising from the Horizon cases, as well as implementing the changes needed to ensure that such issues never arise again. And then a thank you. So, as far as you're aware, was this the end point or the culmination of the consideration by government as to its approach to your decision not to disclose the report to the Post Office Board back in 2015?
Well, I received this letter, when is it dated? At some point in
October 2020.
In 2020. And I haven't heard anything subsequently, so I think you can conclude from that that the answer is yes.
That was the end of it. Okay. Can I just go back to what you and the Chief Executive, Paula Vennells, did say about the report and its recommendations at the time, to see, irrespective of the approach that Bayes and government took subsequently, what information was disclosed? First, by looking at poll 0015-8304.
And by the way, may I say something on this letter before
Absolutely.
we move on? Can we just
go back to the first page?
Scroll back to the
Yes.
first page, if that's all right.
And then scroll down.
Okay. So let me, I think, again, at the risk of sounding a little boring on the subject, I think it's important to place what I would accept with hindsight was a misjudgment in context.
Thank you.
So the first point to note is that I'm not a lawyer, and I received very strong legal advice, which I took. The second point is that I did that in good faith. I had no reason to deliberately hide this thing or chuck it into the long grass. And the third point to make is that it's easy in the context of this inquiry to imagine that all the chairman is doing is looking after issues to do with Swift and looking after issues to do with Horizon. And I have to keep reminding you that that is not the case. There's an awful lot going on in this business and an awful lot of stuff that needs addressing. So having had, slap over the wrists from this, I can perfectly see the response, but I think I'd just like you to bear in mind that there is context to these things, and it's sometimes easy to overlook that.
I think that context should include that when you started working as chairman, you were working for 1.5 days, a minimum of 1.5 days a week. We can get into a discussion about what makes an effective time allocation. I was just asking the simple question, Mr. Parker. When you started, you were on a minimum of 1.5 days a week.
Are you asking me that as a question of fact, are you?
Yes.
Yes.
And then also a question of fact. In November 2017, you asked for that to be reduced to 2 days a month, didn't you?
I did. Can I also, as you've asked the question about time, just explain to you a little bit about the perspective of being a chair and time and what makes an effective chair? Based on the experience that I've had. So being a chair is about a number of different things, and it certainly is about time spent in a business, but it's also about the capacity to understand business problems and the capacity to strike up effective relationships with the key people in a business, especially the CEO. So you asked the question immediately after this about time, with a slight implication, I suspect, maybe wrongly, that somehow what happened here was the result of me not spending enough time at the post office. And I would certainly rebut that suggestion. I would say that I was a very active, energetic chair who took a lot of time and spent time with people to understand the business. And I certainly don't think the time, 1.5 days or whatever it is, was the reason why I made this error of judgment with hindsight.
Can we go back to the note, please, at poll 0015-8304? This was the note I was going to move to look at what was said by you and the Chief Executive about the Swift review at the time. These are speaking notes for a board meeting of the 22nd of January 2016, seemingly speaking notes of Miss Vennells. And can we go forwards, please, to page 6, please? And scroll down, please. Thank you. Just there, Sparrow, Chairman's Review. So remember, this is 22nd of January 2016, before the formal report was received on the 8th, or the final report was received on the 8th of February. Jonathan Swift and Christopher Knight, the barristers advising Tim Parker on the adequacy of scheme processes, shared their draft report with the chairman last week. The report sets out a limited number of recommendations, and Post Office will, where possible, take these forward to demonstrate the highest possible standards of rigour and fairness in the handling of the Horizon-related complaints. Is this the kind of information, to your recollection, that was provided to the board, i.e. the extent of the information provided to the board about the contents and recommendations of the Swift review?
I think she also had a table of the recommendations, but that's it, yeah.
Was it your view that the report did set out only a limited number of recommendations?
the way it's put there, it's sort of fairly kind of benign. I mean, it set out eight recommendations. I mean, it depends on your language, doesn't it?
I mean, it might be said that underplays the overall outcome.
I think that's you could say it's a limited number because there aren't many, or you could say it's kind of gives the impression there's not much going on. Yeah.
Let's just look at what the Minister was told, UKGI 406482. This is a couple of days later, 26th of January 2016, meeting between you, Baroness Neville-Rolfe, Laura Thompson and Andrew Smith, and then main points. The first few bullet points concern other things, which is reflective of the point you made a moment ago, Mr. Parker, that this wasn't the only issue. If we look at the penultimate bullet point, TP, that's you, Tim Parker, updated on the Horizon investigation. He said that the QC was about to report. He had found no systemic problem. Tim Parker thought that the issue might have passed its peak interest. Firstly, did you say that to Baroness Neville-Rolfe?
I have no idea. I think I certainly would have commented that as far as the computer system is concerned, coming back to our previous discussion, and I think it was reflective, broadly speaking, of what was in Swift. There wasn't a systemic problem, whatever systemic was understood to mean. In terms of the second thing, I think I must have just commented that in terms of the press, it had at that point passed peak interest. And that might have been in response to a question or whatever. But that would have just been me commenting on that.
Were they truly the takeaways from the Swift report, as reflected there, no systemic problem, issues past its peak interest, rather than he's made 8 recommendations of substance that need taking forwards, they pose significant reputational issues to the Post Office?
I don't know. I mean, I'm not sure what the substance of the conversation is or why those are the 2 sentences. I just can't tell you. I just come back to what I said, which is that it was a report, which I think it wasn't the final report at that point, was it?
No, not by this time.
Yeah.
I think the 8 recommendations at this time were as they were to appear.
They were. Yeah, you're right.
Lastly on this then, before we break for lunch, can we look at poll 302-4913? Thank you. This is a formal letter that you sent to Baroness Neville-Rolfe on the 4th of March 2016. We were looking previously at a board meeting in January and a meeting with Baroness Neville-Rolfe in January. This is therefore after the 8th of February 2016 final report had been provided. And you say, at our meeting on the 26th of January 2016, that's the one we've just referred to, I provided you with an update on the work I've undertaken with the assistance of Jonathan Swift and Christopher Knight, both of 11 KBW chambers, to review the Post Office's handling of complaints made by sub-postmasters about the operation of the Horizon software system. I now write to set out further information about the approach to the review, the scope of work undertaken so far, and my initial findings. I also outline my plans to bring the work to a conclusion. Before doing so, I wish to stress that this update and the work which underpins it reports on the legal advice I'm currently receiving and is accordingly subject to legal professional privilege and provided in confidence. What does that mean, that sentence?
I, again, followed the suggested text around legal advice, and there was this concern, which I think think I've highlighted around, anything that goes into the hands of ministers and civil servants is potentially disclosable under freedom of information. And that seemed to be a concern that generally coloured discussions of this thing.
In fairness to you, this was a letter drafted for you by Miss MacLeod, and the draft of the letter was itself reviewed by Mr. Swift before it was signed. And I think you were told by General Counsel that the letter had been amended to reflect amendments that he had suggested. You cover that off in your witness statement.
That's
paragraph 65.
Exactly the case, yeah.
The letter continues, I'm of course aware that once the additional strands of work I'm pursuing are complete, we will need to find an appropriate method of communicating the results of my review to a wider audience. In the first paragraph, you refer to my initial findings, and in the second paragraph, you refer to my review. Had you made any findings, and had you conducted a review?
I think that's a little semantic. I mean, it was conducted on my behalf, and whether I sort of finessed the thing to suggest it was only me or my review, I certainly took responsibility for it, which is the main point, I suspect.
The purpose of asking the question was not to delve into semantics, but was to understand whether you understood this to be your findings and your review, and whether you had the opportunity to disagree with anything that Mr. Swift had recommended.
I think it's fair to say that, as I discussed earlier this morning, I thought the Swift report was a good piece of work, and it came out with some good, sensible recommendations which I supported. And I did discuss the report with Jonathan Swift, and so at that point I'm sure I felt happy and willing to take ownership of it.
You say under scope of the review, my objectives were as follows, and then you set out the essentially the term of reference. And then if we go over the page, please. There is then, over the course of 4 pages, a summary of the headline findings of the review and the recommendations made against each of them. So to that extent, the government was informed of headline findings. I'm not going to go through each of them now, and the recommendations made. If we go to the last page, please, page 4, if we just scroll through to, rather than, so you can, and others can see the detail that was included in the letter going to government. Thank you, stop there. Under next steps, I've commissioned independent persons to undertake the necessary work. I'm satisfied that they meet the standards of expertise and independence appropriate to the tasks. I share your aim that matters should be drawn to a conclusion as soon as possible, consistent with the need for the work that remains to be done to a high standard. I hope you understand that, particularly in relation to the further testing of the Horizon system, this work may take some time, maybe a report in May. And then skipping a paragraph, 2 matters. As I've noted above, a number of sub-postmasters have made applications to the CCRC for the circumstances of their convictions to be looked into with a view to those cases being brought back to the Court of Appeal. That work's ongoing. Second, Jfsa is reported to receive funding to instigate civil proceedings against the Post Office. Time of writing, no claim has been issued, nor any letter of claim received. So overall, you were, I think, advised to write a letter of this length and detail. Is that right?
Yes.
And therefore happy that this information was not itself information which would lose privilege.
That's quite an interesting point, and I think my sense is that this letter was written. Yeah, I mean, it's quite a good summary. I agree, but I think that it's probably trying to go as far as possible to outline Swift without necessarily handing the report over.
Thank you. So it's 1:10. Can we break now, please, to 2 o'clock?
Yes, of course.
Thank you very much, sir.
Thank you.
Good afternoon, sir. Can you see and hear us?
Yes.
Thank you very much. Mr. Parker, can we turn to the recommendations, the 8 of them, that Jonathan Swift made in his review? Who, in your view, was responsible for determining whether and to what extent the recommendations should be taken forwards?
So this responsibility I delegated to the General Counsel.
Why did you delegate responsibility for deciding which recommendations were to be taken forward to the General Counsel?
I rather assumed that all of the recommendations were going to be taken forward.
So I asked whose responsibility was it for determining which recommendations were taken forward, and you said you delegated that to the General Counsel.
I'm sure we discussed it, and obviously we ended up with a selection of different people looking after different recommendations, as I recall.
But before coming to the issue of who carried some of the recommendations into effect, was there a person who had a responsibility for determining whether the recommendations were taken forward or not?
As I understood it, the General Counsel.
You also said that you thought that all of them were going to be taken forwards. Is that right?
Yes.
So she didn't have anything to determine?
I don't think so, no.
Right.
Yeah.
So your understanding was that all 8 recommendations were going to be taken forwards. What role did the General Counsel, Jane McLeod, therefore play?
Her role was to work with the relevant parties and report back to me.
Is that the role that you delegated to her then?
Exactly.
Rather than deciding which recommendations were or were not taken forwards?
I see your point. As I recall, there wasn't a debate about which recommendations, but just to take all of them forward with appropriate parties.
Did it occur to you that the board ought to play a role in deciding the extent to which recommendations were taken forwards, and if so, how they were to be taken forwards?
We had a situation after the report was completed where, as I think I explained, the report wasn't shared with the board, and the understanding was the recommendations would be taken forward, and my plan was to share the outputs at that stage. So this was something that went straight from the General Counsel to the relevant parties, and so the board was not involved, no.
Was that a product of the legal privilege issue that we discussed this morning?
It was a product of the perception that I had with the legal privilege issue, yes.
Thank you. Can we look, please, at poll 00103190? And the bottom email, please. 13th of May, 2016, Jane McLeod to you. Here is my regular fortnightly update on the progress of your review and the litigation. Is it right that she provided an update regularly to you?
Yes. I mean, I'm sort of drawing that conclusion from the first sentence here.
Was the relationship between you and Jane McLeod essentially one-to-one, i.e. you saw her as driving the recommendations forward as appropriate on your behalf?
Yes, I think that's a fair characterisation.
She says, we can look at these quickly, helpline, in relation to the allegation that our helpline may have provided incorrect advice to sub-postmasters, which resulted in a loss to the accounts. Bond Dickinson, the external firm conducting the work, has now completed its investigations. Although some investigations were limited because certain records are no longer available and there were inaccuracies in the information provided by the complainants, their draft report reveals there is no evidence to support the allegations that have been made. We're currently reviewing the report ahead of it being shared with Jonathan Swift to seek his view as to whether it sufficiently discharges his recommendation in this area, but we're confident that it should be. And then Horizon System, we've had further meetings with Deloitte in relation to the extent of the work necessary to discharge Jonathan's 3 recommendations excuse me, on the testing of Horizon, and they have begun work on the substantive phase of that work. It's by its nature an iterative process that, dependent on early results, further decisions then need to be made on whether or not to explore further. I've asked the new CIO, Rob Houghton, to review the process undertaken by Deloitte to sense check these further decisions. Suspense accounts, Deloitte are also conducting the work into the existence and nature of the relationship between Post Office's suspense accounts and specific branch accounts over the relevant period. This is materially different exercise to the IT testing, and I understand that most of the relevant accounting processes were or are paper-based records and manual reconciliations. And prosecution practice, Jonathan Swift has confirmed that Brian Altman can limit his initial review to those 19 cases presenting the specific features of double charges in question and decide on the basis of those findings whether to extend the exercise. That work is ongoing. And if we go back to the top of the page, page 1, you say, I think there will be frustration at the time this is taking. Indeed, I'm also beginning to get somewhat frustrated. What's the projected timetable for completion of the components of the action list? Does that reflect the fact that the report had been provided to you in draft in January, in final version on the 8th of February, and it was now mid-May, and the work was inchoate?
I think that's true. That's what I was expressing at the time.
Did you pick up from the chain that the recommendations made by Mr. Swift were being trimmed?
No, not especially. Why? What's behind?
Altered.
I don't think so.
I mean, to take an example.
Yeah.
Over the page, prosecution practice. Swift has confirmed that Altman can limit his review to 19 cases presenting specific features and then decide on the basis of those features whether to extend the exercise. That wasn't the initial recommendation. Recommendation was to review all of the cases, if you remember the recommendation number 1 and 2.
I see your point. I think I would have taken that at face value to mean that she had talked to Jonathan Swift, and between them they'd taken a view that that was going to respond to the recommendation adequately. I hadn't picked up, to be honest, that things were being, to use your phrase, trimmed as such.
Can we go forwards, please, to poll 0024 1554? We can see at the foot of the page your email. There'll be frustration, yes?
Yeah, yeah.
And then top of the page, please. You'll see that Jane McLeod forwards the email to, circulates the email to a small team of people, Patrick Bork, Mark Underwood, and Roderick Williams.
The very same people who received the copy of the original Swift report.
So it's the same select few?
Exactly.
Please see email from Tim below. It will be helpful to be able to respond with the status of each of the 8 question mark actions that were being carried forward, a description of the remaining work and expected completion time. We should consider the work being done by Deloitte and how far we want to address the questions posed by Jonathan. Just stopping there, was it for this small team to decide how far we, presumably the 4 of them, want to go to address questions posed by Jonathan Swift?
So I think I come back to where I started on this, which is that I assumed perhaps wrongly in retrospect, but I assumed that the General Counsel's team were A, competent, B, would do things in good faith, and C, would respond effectively to the recommendations of the report. Now, you know, when you get to see these emails that are shown to me or form part of the evidence base, which are what's going on, as it were, behind the scenes, it kind of puts a different complexion on things a little bit. So the reason I mention all of that is that, you know, I'm expressing to you what seemed to me to be the case. Behind the scenes, of course, you find that, you know, the motives for doing things perhaps are not quite as straightforward as one might have imagined.
There's no suggestion, from me at least, that this email was provided to you. Was it right for this team to be seemingly determining whether the recommendations were taken forwards, and if so, in what way?
So, in the world that I normally exist in, I have people working for me, and they have a job to do, and if I ask them to do a job, they understand and it's correctly specified. Until I got to the post office, I think I'm right in saying that throughout my career, I have found that people went and did what was asked of them with suitable determination and suitable application of their abilities. And so, in retrospect, you might say, well, these are not the right people because here we are at the post office. But I can only tell you that under normal conditions, they should and would have been the right people and could well have carried out these recommendations effectively.
Can I ask you two questions arising from that? Do I take it from that answer that if you had known that this small team had taken upon itself the function of deciding how far to go to discharge a recommendation, you would have had something to say about it?
I would have been concerned. I mean, it was straightforward. Here are the recommendations. You know, let's go and do something about them.
And the second thing is that you didn't therefore know at the time that this subsurface internal debate within a select team within Post Office was going on?
No.
The email continues, given the litigation, I suspect there's even less we're going to be able to say about the results of the further work. So we need to consider the value to be obtained from each step. Again, that's a similar point, i.e. The team determining value to be obtained from further work, in part based on the extent to which something can be said about the results of it. Does the same answer that you gave a moment ago apply?
I can see your point. If I may make one general observation about this sort of backward-looking, what were people doing 8 years ago type thing, that you can only look at the evidence that you have on a piece of paper, and people write sentences which can or cannot reflect truly what was going on. So I'm not here to, you know, doubt what's actually written here. But sometimes things that are recorded don't exactly reflect what people were doing at the time. I don't know in this case. I just think it's worth bearing in mind that you cannot take every sentence that is written and that you read as gospel in this context.
That's certainly the case. A number of people have sat in your chair and said that what they wrote does not reflect what they meant at all.
Very good.
Can we move on to poll 0010-3214? And look at page 2, please. And just scroll down. Thank you. It's an email later that month. We were just looking at the 14th of May. We're now looking at the 27th of May to you. And Ms. McLeod says, as flagged at the board earlier this week, I hosted a call with Jonathan Swift today to ask what, in his view, would be a reasonable course of action for you to take in relation to his recommendations as to the further lines of inquiry which could be undertaken now that the Post Office faces litigation covering essentially the same ground. And so just stopping there, can you recall who told you and how about litigation being threatened against the Post Office on behalf of sub-postmasters?
I believe I must have been told at some point after the receipt of the letter of claim. Now, the letter of claim, I think, came in middle of April or end of April, something like that.
Can you recall whether you were told that this may have an impact on the extent to which the 8 Swift recommendations could be carried into effect?
I can't, to be honest. I don't know. I can't tell you whether this was the first, glimmer of that happening.
That's essentially what I'm driving at.
Yeah. I'm not, honestly, I can't tell you for sure.
In any event, Ms MacLeod reports, in summary, Jonathan felt that Tony, that should be Degar Robinson, QC, the barrister retained to advise Post Office on its defence to the proceedings, should be requested to advise Post Office whether in the light of the litigation, the various works teams should be continued, paused, or redefined. So that's essentially telling you that she went off to Mr. Swift, who said, don't ask me in the first instance, go to the person that's conducting the civil litigation, Robinson QC, and ask him. Yes?
That is exactly as I understood, with hindsight, is what happened, yeah.
We will send instructions to Mr. Degar Robinson early next week and expect to have his advice relatively quickly. Once this advice has been received, Jonathan has said he'd be happy to discuss with you how best to take this forward in the context of your review, as well as considering how to position this with Baroness Neville Rolfe and others with knowledge of and interest in the review. Was this your main means of communication with Jane MacLeod, i.e. email, rather than attending the office and having meetings?
No, I'm sure we spoke about it. I'm sure she just sent me an email about it.
Okay. You think there was discussion outside of the email as well?
I honestly can't confirm that.
Can we go forward to page 1, please? And scroll down. On the 10th of June, Jane MacLeod writes further to the email that we've just looked at and says, we met with Tony Degar Robinson last night to discuss the postmaster litigation. In the course of that discussion, we asked him for his advice as to whether the work being undertaken for the purposes of your review should be continued. His strong advice was that the work being undertaken under the aegis of your review should not continue in the light of the litigation. However, he also recommended that the subject matter of that work should continue, provided it is rescoped and re-instructed for the purposes of the litigation. Clearly, you'll need to inform the Minister. We'll prepare a form of words, and then over the page, sign off from Jane MacLeod. And then top of page 1. Let's meet on Thursday to discuss, yes?
Looks that way, yeah.
Now, the Swift review was a significant piece of work, wasn't it?
It was.
It contained recommendations that went to the issue of uncovering potential miscarriages of justice.
It did.
It plainly took a long time to research and complete, and it was a comprehensive report, wasn't it?
Indeed.
Given that one of the reasons for undertaking the review and some of the recommendations from it related to matters touching on the safety of criminal convictions, did it occur to you that undertaking the recommendations through the aegis of civil litigation against the Post Office was not the right way forwards?
So I think we're back to this question of, in this kind of situation, which I had very little experience of hitherto, receiving advice from senior counsel on a legal matter, very strong advice apparently, I took that advice and I assumed, perhaps erroneously, that the General Counsel, who also herself was a lawyer, would have considered and appreciated any implications, ramifications of doing this in terms of how the Swift report was carried forward. So it's a very difficult question because, you know, when you look at these things with hindsight, you say, well, you could have spent some more time discussing it, or you could have had your own view, or you could have done this. The problem with experts or specialists is, how do you judge the view of the specialist? Do you get another specialist to advise you on the specialist? Or do you draw the conclusion that your judgment of the specialist was wrong and the specialist you've got is no good? Or that the General Counsel who is advising you is somehow incompetent? Or the whole bunch of them have somehow some rather nefarious, underhand objective of potentially holding things up? I'm not sure, but at the time, I took at face value what I thought was good advice and the right advice from people who apparently were qualified to give it.
So is a summary of that answer that you thought it reasonable to rely on the advice of your General Counsel, who had asked the Silk the very question that you needed to be answered, and he had provided an advice which was said to be very strong?
All I'm saying, and you're right, it's not a bad summary of my 10 or 12 sentences, that whether it came from Mr. Swift or and with Jane McLeod, they're both lawyers, they both understand what's in the report, they are and were both qualified, and certainly he was, to give a view, yes.
Do I take it that it didn't occur at the time that what might be in Post Office's narrow interests in the conduct of the civil litigation might not be in the wider interests of wrongly convicted sub-postmasters?
So I think we're touching on this question of, with hindsight, of course, it would appear that there were motives perhaps underpinning some of the advice or the direction of this that were not wholly fair or right or in the interests of people who had been wronged. At the time, however, it seemed to me that the people giving me advice should be and were doing this in good faith, and it was the right thing to do.
Thank you. Can we move forwards? Poll 0024-2402. And if we can go to page 4, please. This is a chain that you're not copied in on, but it attributes to you and to the Post Office some beliefs or intentions. So I want to ask you about them. It's the 8th of June now, an email from Andrew Parsons, the partner at the firm of solicitors that the Post Office was using to defend the threatened litigation, to Anthony Degar-Robinson. And he says, Tony, I met with the Post Office Litigation Steering Group yesterday. Just stop there. Were you a member of the Litigation Steering Group?
I wasn't.
Do you know who it consisted of?
I do. I'd have to have a piece of paper in front of me, but in summary, it was a collection of Post Office executives and specialists and legal people.
Their approach to Jonathan Swift's recommendations has shifted slightly. Tim Parker feels that he has made a commitment to Baroness Neville Rolfe to follow through on the Swift recommendations unless he is presented with a persuasive case not to do so. Is that accurate, that you felt at this time you'd made a commitment to the Minister to follow through on the recommendations unless you were presented with a persuasive case not to?
Yeah.
So that's accurate. And then Post Office are looking to us, and frankly you with your magic QC seal, to give them some reasons for why Tim completing the Swift recommendations would be ill-advised. First, Post Office are looking to us, i.e. to the lawyers, and to Mr. Degar Robinson, to sprinkle some magic dust on the answer for reasons why the recommendations, completion of the recommendations would be ill-advised. Was that a message that came from you?
You mean this about magic QC seals? And,
No.
sorry.
Put aside the magic QC seal. The description of Post Office are looking to us for reasons not to complete the recommendations.
Yeah, well, you know, again, as you said at the outset, this is something that's going on without my knowledge.
That was the question.
Yes.
Was this going on without your knowledge?
And just to be clear, it was without my knowledge.
So you weren't looking for lawyers to come up with reasons not to do or undertake the Swift recommendations?
No.
Do you know who was? It's described here as Poll are looking to us.
Yes, I see that. Well, it's I certainly wasn't part of the, hey, you know, can you get Tony to give us some reasons why we should let up on this?
Yeah, some top cover, some
No.
legal insurance or other such phrases I've heard in my career. That wasn't coming from you.
That wasn't coming from me.
Did you know that, in any way, that there was a group of people within the Post Office looking to stifle or end the carrying into effect of the Swift recommendations?
The answer to that question is no.
If we scroll down, the recommendations we're talking about are, and then they're set out, 1, 2, and 3. My view, that's Mr. Parsons' view, is that the 3 recommendations plainly overlap with the issues in the litigation. I can see 3 reasons why Tim should not conduct the above investigations. 1, we, the litigation team, will need to investigate these points. We'll probably need to do this on a different timetable to Tim. We having a degree of time pressure, Tim under less time pressure. We will probably require a more robust investigation, given that these points could be tested in court. 2 parallel reviews could be wasteful and cause unknown complications should they reach contradictory results. Was any of this reasoning ever explained to you for not simply carrying into effect the Swift recommendations?
No, I had certainly not this kind of rationale, no.
2, if these investigations are conducted by Tim, there's a greater risk that this work is not privileged. It will be much safer for the investigations to be conducted as part of the litigation. Was that explained to you?
No, I think the one sort of view I had was that this review should be stopped and repurposed as part of the litigation, and because of the litigation, the work would continue to be privileged.
3, even if the risk in 2 above could be guarded against, say by classing it as part of Swift's ongoing advice to Mr. Parker, questionable. I cannot see how you, Mr. Parker, could disclose the results of these investigations to the department without a risk of waiving privilege, particularly where there's a possibility that Baroness Neville Rolfe may then speak to James Arbuthnot, or Post Office or Biz could be the subject of a FOIA request. Was that explained to you as a reason for not carrying into effect the Swift recommendations or any of them?
No, essentially, what I got out of all that was what you saw in, a couple of papers ago, which is I can't remember the exact description, but it was something like the strong advice of senior counsel, the work should be discontinued and repurposed. I can't remember the exact form of words, but that is the advice that I received.
If we can give Post Office a piece of advice that says that you should stop any further work, you would then feel empowered to say to the department that on the basis of legal advice, he's ceasing his review. I'm conscious that this feels somewhat unpleasant in that we're being asked to provide political cover for Tim Parker. However, shutting down Tim Parker's review is, in my view, still the right thing to do. The way that last paragraph reads, would you agree, is it implicates you somewhat in the making of the request?
Well, I mean, I certainly was not aware of all of this stuff going on, as it were. And it certainly makes me look a little bit, like these guys are marionettes and I'm sort of, doing my little thing in response to bits and pieces that they're putting forward. And that's, very disappointing with hindsight, because you, as I was explaining earlier, you expect to get advice from lawyers in good faith with, good motives and a good rationale, and I assumed that was what I was getting.
And so, directly to answer my point, to the extent that this last paragraph implicates you in the sense that it says that you would feel empowered to say, on the basis of legal advice, you are ceasing your review, and that they, the lawyers, are being asked to provide political cover for you. Neither of those things are things that you asked for.
No, I got the advice and then used the advice to essentially communicate with Bays.
So you
I didn't feel empowered myself. I wasn't aware of being empowered because, I wanted a reason to go and tell Bays the thing was being discontinued. I received that advice, and as a result of getting that advice, I went and then communicated it to the civil servants and onwards to the minister.
Can we move forward, please, to poll 0024 2552? If we just go to page 3, please. Just to remind you, foot of page 3. We met with Tony Robinson to discuss the postmaster litigation. Second paragraph, his strong advice was that work being undertaken under the aegis of your review should not continue. Yes?
Yes.
10th of June. And then page 2 at the bottom, please. Um, 14th of June, see below, that's that chain, and your reply saying, let's discuss on Thursday. Jay McLeod and Roderick Williams and Patrick Borg in email discussion. Any approved messaging we want to get across. Did you know that the small select team were formulating messaging for you?
No.
Up the page, please. In terms of messages to Tim and from Tim to Baroness Neville Rolfe, I think we're going to have to address the issue head on. The litigation makes the review irrelevant, since the issues to be considered will be put to a higher standard of testing in the courts. Was that ever explained to you, that the review was now irrelevant?
I can't remember that it was explained in those terms, no.
Because of it is said, a higher standard of testing in the courts. That wasn't ever explained to you?
I can't be sure. I mean, I think the main reason this ended up where it did was the advice I referred to earlier, which is the strong advice from external counsel. Whether or not this was added, as a sort of a rationale, I can't be sure.
the email continues, to continue would be fruitless, since we couldn't use its output, senseless in terms of expenditure, and present unnecessary risk to the organisation's legal position. Were those reasons for the review being irrelevant put to you?
No.
To my mind, in any event, it's now clearer than ever that the review, or indeed any other exercise not involving a third-party adjudicator, not a mediator, just isn't capable of putting these issues to bed in the minds of some. That does not need to be pitched as a bad thing. Yes, it frustrates the review and is uncomfortable, but it has the clear merit of being independently determined and final. Before you joined, I was racking my brain with others about how we might find a way of getting these cases, or one of them, into the court. None of this is new, but I do think the trick will be in the cell. Anyway, that's my view. Was it explained to you that the review was irrelevant because it wasn't capable of putting issues to bed in the minds of some?
All of these ruminations, which is from Patrick, is it Patrick Burke?
Yes, this is Patrick
Burke. You know, I had, as I've explained twice, the way it was represented to me was that Degar Robinson, who was the senior counsel, advised, and on strong advice, that the report should be discontinued and repurposed. I can't ever remember receiving all of the, you know, the product of this kind of thought piece or whatever, you know, so justificatory type logic. No.
Well, it might not just be a thought piece or justificatory logic. It might be revelatory of the true reasons operating on some people's mind for not continuing with the Swift recommendations. And they were instead badged up to you as needing to be stopped because the Silk had said so in strong terms.
You know, it looks that way, doesn't it?
Yeah. Thank you very much. They're the only questions I'm going to ask you about the Swift review. Can we turn to a separate topic, please? The conduct of the group litigation. You've addressed this in very considerable detail in your helpful witness statement, and therefore I'm not going to ask you about a lot of it because you have exhibited to your witness statement a very large volume of material, contemporaneous material, that explains your conduct and the conduct of those around you. So just a few topics, if I may. Firstly, can we look, please, at the one of the first excursions into court and the outcome of it, namely the strikeout application, by looking at poll 0010 3351. And look at the foot of the page, please. We're now in October 2018. It's an email to you, copied to others, from Jane McLeod. And she says, I understand Tom Cooper has recommended you read the judgment from the hearing last week, and it's attached. We received the decision on Monday evening, and the decision rejects our application for strikeout of significant parts of the evidence contained, I think that should say, in the claimant's witness statements. The application was decided on case management grounds, for which the managing judge has considerable discretion. Applying that discretion, the managing judge set a very high threshold for strikeout and concluded that we had not established to the necessary standard that the claimant's evidence could never be relevant to the case, given the number of common issues, the considerable legal analysis each will require, and what our case on those issues is. He confirmed he will apply properly the law on admissibility when it comes to trial, and the November 2018 Common Issues trial will not rule on matters which concern Horizon or which whether Post Office actually breached its obligations to the claimants, matters to which most of the disputed evidence goes and which will be dealt with in later trials. As previously advised, this is consistent with the managing judge's approach of wanting to give the claimants their, quote, day in court while applying the orthodox legal position. That said, we lost the application and can expect the claimants to be awarded their costs when that question is dealt with on the first day of the trial, estimated to be £120,000. In deciding the application, the managing judge was critical of our conduct of the case, see particularly paras 55 to 57, including intimating that we were not acting cooperatively and constructively in trying to resolve this litigation, which criticism was levelled equally between the parties, and that we had impugned the court and its processes by making the application for improper purposes. This response is extremely disappointing, given the approach we've been adopting, and his challenge as to the purpose for which it applied for strikeout is at odds with the comments he made during the various procedural hearings over the past year. Nevertheless, we're refining our preparation for trial, including our reactive communications plan, in the context of the judge's remarks. And then back to page 1. You say, thanks, I've read the judgment, and the judge does seem to be somewhat negative about our efforts to take out elements of the evidence, even if he does acknowledge that both sides have been uncooperative with each other in the management of the case. My worry is that some of his points at the end betray what looks like an inherent dislike of our aggressive approach to the individual claimants, as well as an aggressive approach to litigation, as well as a rap over the knuckles regarding what the judge sees as using negative PR as part of our argument. Interesting to know if this initial response from him suggests any change of tack on our part. So I think, would it be fair to say you were concerned about the judge's criticism of the Post Office?
Yes. Was this, just to be clear, was this the case management conference number 2? I'm just trying to, get the chronology. So we had case management conference number 1, at which point he was quite critical of both parties, who he said were being uncooperative.
I think that was in March 17.
And this is number 2, is it?
I don't think it's actually CMC number 2. I think it's a separate strikeout application.
Okay. So progressively, the judge, as I read things, became more critical. And what began as a sort of fairly even-handed criticism of both parties, I think by this time he had started to become somewhat critical of the Post Office. And that's why I suspect I asked, so what do people think of this, actually?
The words that were reported to you and which appear in the judgment, namely the Post Office have made the application for improper purposes, are quite strong, aren't they?
They are. And also, one of our people, apparently, this is the PR reference, I think, said something like they felt some of the additional evidence could potentially damage the reputation. I can't remember what that. So I knew what the issues were, and that was really why I was asking the question.
So you say at the end, interesting to know if this initial response from him suggests any change of tack on our part. Is that a question back to Jay McLeod?
Yes, I think I'm obviously, without wanting to sort of immediately prod and say, look, it looks like you're wrong, I'm inviting a comment.
And that leads me to the question, what role did you play, therefore, in setting or amending the Post Office's strategy in the group litigation?
So I think you'll see, I don't know, there's another email chain subsequently where the point is made to Jane, and there are various responses around a change of tack, etc., somewhere, I think.
I think that's much later.
Is it? I'm sorry. There's so many documents. It's hard to. So I'm not. I mean, I can't tell you if we don't have any documents exactly what the output of this was. At this stage, there's obviously some concern, but and the point has been made. I'm not quite sure what happened as a consequence of me inviting some kind of response here.
And so back to the question of what role did you perform? You weren't a member of the Litigation Steering Committee.
Well, by this time, I may be wrong, this is
October
2018, we had formed the board subcommittee, and so I'm not quite sure whether this is in the context of the executives or whether this is something that was going through the board committee. I would presume that this was an exchange between myself and the executives.
Is that because of those that are copied in on it?
I'm assuming that, yeah.
Again, approaching the question from a different perspective, who determined the Post Office's litigation strategy?
So at that point, we had a board subcommittee, and the arrangement was that the executives managed the day-to-day elements of the litigation and were required to escalate any significant decisions to the board subcommittee.
Did government have any role in the strategy that the Post Office took to the litigation?
Well, Tom Cooper was a member of the board subcommittee, and one of the key reasons he was a member of the board subcommittee was because he was the Bayes representative on the board.
Can we turn forwards then to poll 00103352? Foot of the page. Same day, 18th of October, 10:30. Tim, have you seen the judgment from the other day? It's worth a read. And then further up the page. Your reply, same day at 2 o'clock. I've now read it. Judge is critical of both parties, but already sense he's not well disposed to us. The word aggressive is used a couple of times in connection with us in relation to the inadmissible evidence claim and the treatment of a sub-postmaster. The tone of his comments at the end on the common issues trial and the purported objection on our part for PR reasons is definitely not helpful. I've asked for an update on whether this ruling and its tone suggests any change of tack.
Yes, so that was the chain that I was referring to earlier, where I think we picked up, you know, the critical comments of the judge, and at that point was asking, so guys, what are you going to do about this?
And so what happened as a result? You've asked directly Jane McLeod, copied to Paula Vennells, does what has happened on this occasion, resulting in the publication of this judgment, suggest a change of tack? So UKGI have sent the same judgment to you, saying it's an interesting read. You've replied saying exactly what you've done. What happened?
Yeah, so Tom and I were colleagues on this committee, and I don't know if someone can bring it up, but there is a subsequent email chain, and someone has spoken to Jane, and I think it was Paula Vennells summarised a list of outputs from that discussion, which I can't remember which document is relevant to this, but there is one.
I will endeavour to search for that whilst other people ask you some questions, because I don't have it at my fingertips at the moment. So is the answer then that the primary vehicle for setting the strategy was the subcommittee?
Yes.
But there were back channels of communication, such as this one, in which members of the subcommittee communicated?
Yes, I think the broad, I can't remember there is a document somewhere with the terms of reference of the subcommittee, and from memory, it makes fairly clear that the management of the litigation is by the subcommittee, and executives who manage the thing on a day-to-day basis need to escalate matters to the committee as appropriate.
We shouldn't see this kind of communication as a means at which strategy was decided or carried into effect.
Well, I suppose in a way you've got myself, Tom Cooper, and I'm not sure if at some juncture Ken McCall, who was another member of the committee, would have been involved in this, but I mean, it at least is being dealt with, and 2 significant members of the committee are aware of it.
Thank you. Can we move forwards, please, to March 2019 to look at the recusal application? Can we start by looking at poll 302 3898? And look at page 2, please. An email of the 15th of March 2019 from Jane MacLeod to you, Tom Cooper, and Alistair Cameron. She says, as flagged on the board call on Tuesday, we sought further advice on appeals and whether we have grounds to request the judge to recuse himself on the grounds of bias. So I think the board call previously was the Tuesday of that week. We sought advice from Lord Neuberger, who stepped down last year as President of the Supreme Court and was the highest judge in the United Kingdom. We sought his views as to whether the draft judgment demonstrated the following grounds for appeal, whether the judge has correctly interpreted and applied the law as to construction of a document or application of a principle of law, whether there are grounds to argue his findings, that findings have been made as a result of serious procedural irregularity, which goes to the admission of and reliance on, amongst other issues, inadmissible evidence, and most urgently, whether Mr. Justice Fraser demonstrated grounds on which we could apply for him to recuse himself. The test for recusal is whether the fair-minded and informed observer, having considered the facts, will conclude there's a real possibility the judge is biased. Attached is Lord Neuberger's preliminary note. The note is put together, or the note he refers to is put together by David Cavender, summarising the key extracts of the judgment and trial transcript. As you'll see in para 5, he states that although he has only looked at the issues very cursorily, quote, at least some of them raise quite significant points on which the Post Office has a reasonable case, and at least on the face of it, some points on which the Post Office has a pretty strong case. He suggests if we wish to rely on the ground of procedural unfairness at an appeal, the Post Office has little option but to seek to get the judge to recuse himself at this stage. And para 20, if we fail to act promptly, we risk being held to have waived our rights or at least weakened our position on the recusal issue. There's a timetable. The risks are if the application is successful and the trial is adjourned, we proceed with an appeal on the common issues trial and a new judge is put in place. The application is unsuccessful, then it's likely that the judge is further antagonised. However, he will be aware that the common issues appeal is progressing, which includes procedural unfairness or an assertion of procedural unfairness. Possible impact in that scenario is that the judge is more cautious as to behaviours to possibly Post Office's benefit. Over the page, theoretical downside to a recusal application is that it fails and that Fraser remains the judge at trial 3, which will require multiple findings of fact which are more tricky to appeal. We should also not proceed with this course of action unless we're prepared to appeal a decision by him not to recuse himself. I propose today to brief a further senior silk, probably Lord Grabbanner, to act on the recusal application. Next steps, this is clearly a board decision. We'd need to give the board time to consider the options. And then some practical arrangements, given that Lord Neuberger was in Argentina. Do you recall the issue of the recusal of Mr. Justice Fraser being raised in this way?
Yes.
What was your initial reaction, if you had one, to the suggestion that the Post Office should apply to a judge to recuse himself on the grounds that he was apparently biased?
So, if I'm honest, an element of unease. In a way, this is it's a bit analogous to what I mentioned at the outset of today, which is one of the things that would have helped to frame this kind of decision, and indeed the decision that were made at the beginning of this thing, would have been to know, for example, exactly how many postmasters had been convicted And in the same way, in a funny kind of way, this, if I had had some meaningful statistics, I think if all of us had had some meaningful statistics about how often judges are recused, we might have looked at this in a slightly different way, because I have a suspicion it isn't very often. And I think one of the problems was that, you know, if you take advice out of the context of the frequency of the event you're trying to evaluate, you sometimes end up with a slightly distorted view of things. And so, you know, my gut feel, and I'd had something to do with judges, was this, you know, I was a little bit uneasy, I have to say.
What was the cause of your unease?
Simply the fact that, you know, it's quite a big deal to get a judge to accept that they had made a judgment that was wrong on technical grounds.
Can we go forwards, please, to poll 00103446? And scroll down to the foot of that page, please. Thank you. It's slightly difficult to decode exactly what's going on, but it's an email to you of the 16th of March. And Jane McLeod says, below is my high-level summary of the call today. If we go to the foot of that page there, where the summary begins, participants, Kelly Tolhurst, MP, Tom Cooper, UKGI, Gavin Lambert-Bayes, you, Al Cameron, Jane McLeod. And then the text of Jane McLeod's high-level summary commences, and it goes over the page. And if we go to page 3, please. And if we look at the second bullet point down, TP, that's you, replied that we have a board call on Monday evening at which we will discuss issues around the judge's bias and how that could impact on subsequent trials. Although his, that's your initial reaction, is that this is not something that the board is likely to want to do. The board must act in the best interest of the company, so we need to consider that option seriously. If we're to make the application, it must be made urgently, not delayed, etc. So firstly, why were you having a meeting or a call with Kelly Tolhurst MP about, amongst other things, the judge's recusal?
Well, by that time, so just to give the background, so Tom Cooper was a member of the Post Office Litigation Subcommittee. And by that time, because not least the judgment in the Common Issues trial had been received and it was so damning, by that time, I think the department was becoming worried, concerned, and wanted a higher level of involvement. And Kelly Tolhurst was the relatively new, because it was a fairly fast revolving door over there, she was the relatively new parliamentary Undersecretary of State at what was called Bayes at that time, I think. And so the reason she was involved was that, you know, Tom, I think, felt it was necessary to get the minister directly aware and involved in potential decisions that were being made around the judge's recusal.
What part did government therefore play in deciding whether to apply for the judge's recusal?
My assumption is, and I've no means of telling from this or indeed where I sit now, is that Tom Cooper's role was as the department's representative on the board in this board subcommittee. As it happens, he recused himself from the decision because I can't remember, there was you know, some reason about the executive and the judiciary and stuff like that. But essentially, you know, he would have been the conduit through which I would have assumed we were getting a departmental view. Why
did Post Office need a departmental view on whether to apply for a judge to recuse himself?
Well, I think this is simply an example of where matters had got very serious. So you have to see things in the context of the litigation producing an output from the first trial that was a loss on virtually every count, and our sole shareholder beginning to get concerned from all sorts of points of view. Not least, I imagine they could see that there would be significant reputation, significant cost, all sorts of things.
Was it right that your initial reaction, as is recorded here, is that this, i.e. applying to recuse the judge, was not something that the board was likely to want to do?
For the reasons I was trying to express earlier, I think most of us, I'm not trying to be overly complimentary to Win, but most of us think judges usually get it right and, you know, have an inherent respect for the judiciary. And so it would have excited a certain amount of unease in most people, I think, to go suggest that, you know, the judge had got it wrong.
Well, and was biased.
Or biased.
What changed, to your understanding, from your unease at making the application and your reporting that this was something that the board was not likely to want to do, to the making of the application?
So the first point I should make is that, you know, I also recused myself from the decision, but
just to stop there, that was because of your role
at
as chair of
HMCTS.
HMCTS.
But put that to one side. I was there. I would have been involved in the discussion. So that's a bit, you know, I'm not trying to back out of this thing. So we had advice from two sources. We had advice from Neuberger, and we had advice from Grabiner. Grabiner's advice was pretty strong, actually. I think he said something along the lines that we had a duty, almost, to ask for the judge's recusal. And
stopping there, what did you understand? You're right, he did say that. What did you understand him to mean by that the Post Office was under a duty?
I can't recall the detail exactly, but the way the advice was framed was that, you know, we kind of almost to ensure the business of the administration of the law required us, where we thought something had been incorrectly managed for whatever reason, we needed to act upon that.
Just stopping there, and can I put two potential hypotheses to you in terms of the Post Office was under a duty to apply?
Yeah.
One could mean that the Post Office was, as a matter of company law, its directors, it owed a duty to make the application in discharge of its duties to its shareholder. Alternatively, it could mean that if you wish to win this litigation in the final result, procedurally, you are under an obligation to take this point now and not wait until you appeal the substance. Can you recall whether you formed a view as to in what sense you are under a duty to make the application?
Yeah. Honestly, I can't at this distance. I think I don't want to make too much of this duty thing. I think we just got advice from two very, very senior lawyers and felt, on balance, that advice should be taken.
So in answer to my question, the thing that changed was legal advice from two very senior lawyers, one of whom said that the Post Office was under a duty to make the application.
That's a fair description of what happened.
Thank you very much. The last topic, please. You told us earlier that you were not aware of concerns being raised about the Fujitsu employee, Gareth Jenkins, giving evidence in court in Post Office prosecutions that may have been false or incomplete until much later on. You couldn't remember when. Can I ask directly then that we look at poll 406375? my mistake, 6357. Thank you. If we just go to the last page, which is page 14, and foot of the page, we can see this as an advice of the 15th of July, written by Simon Clark in a firm of solicitors that the Post Office used, Cartwright King, to advise it on matters relating to the prosecution of sub-postmasters. If we go back to page 1, it's advice on the use of expert evidence relating to the integrity of the Fujitsu Services Limited Horizon system. If we just look at page 13, please. And the author says, what does all this mean? It means that Mr. Jenkins has not complied with his duty to the court, the prosecution or the defence. 38, the reasons as to why Mr. Jenkins failed to comply with this duty are beyond the scope of this review. The effects of that failure, however, must be considered. 1, Mr. Jenkins failed to disclose material known to him, but which undermines his expert opinion, in plain breach of his duty as an expert witness. Accordingly, his credibility as an expert witness is fatally undermined. 3, in those current and ongoing cases where he has provided an expert witness statement, he shouldn't be called upon to give that evidence. 4, notwithstanding that the failure is that of Mr. Jenkins and arguably of Fujitsu, this failure has a profound effect on Post Office and its prosecutions, not least by reason of his failure. Material which should have been disclosed to defendants was not disclosed, thereby placing Post Office in breach of their duty as a prosecutor. 6, by reason of that failure to disclose, there are a number of now convicted defendants to whom the existence of bugs should have been disclosed but was not. They remain entitled to have disclosure of that material, notwithstanding their now convicted status. And lastly, penultimately, there are a number of current cases where there's been no disclosure, where that ought to have been given. Lastly, where a convicted defendant or his lawyers consider that the failure to disclose the material reveals an arguable ground of appeal, he may seek leave from the Court of Appeal. When were you first made aware of the existence of this advice by Simon Clark concerning Gareth Jenkins?
Oh, well, I mean, probably in reading this in detail, when I actually got all of the, I can't remember, I think it must have been in my bundle. But, I mean, certainly years after the event, I mean, one of the things that struck me was I don't think Swift was shown this.
Correct.
Yeah, so, you know, yeah, I mean, I can't tell you exactly when, but suffice it as to say, I would imagine post the trials, probably.
And by the trial, do you mean the Horizon Issues trial?
Or both. I mean, you know, the point I'm making, I think, is that I would have known about this at the point at which we were reviewing stuff after the litigation, yeah.
Okay, so too late for it to matter then?
Too late for it to matter then, yeah.
But what was your reaction on being provided with a copy of the advice or having it summarised to you? Well,
this is one of the things where, again, I think when you've looked at a lot of the documents that we have reviewed today, it's hard not to draw the conclusion that decisions might have been different had a lot of these things been known at the time. And, you know, this whole terrible raft of events, I think, in part, is because as problems build up over time, the wall against breaking them down gets higher and higher. And this was just part of the wall. And it didn't break down, really, until we got to the litigation, I suppose.
Can we look, please, at poll 0016 7395? These are minutes of a board meeting held on the 19th of November 2020 by conference call, and you'll see that you are present. It's a special meeting concerning the CCRC, and you'll see that there's quite the cast list. If we scroll down, and scroll still further, and then over the page. Second paragraph on that page, Brian Altman informed the board that a layer of complication had been added to the court proceedings yesterday. And then scrolling down, please. That paragraph refers to essentially the disclosure within the proceedings and outside the proceedings of the clerk advice. Okay? That's the earliest that we can see that a reference was made to the clerk advice in any board meeting. Would that presumably you wouldn't presumably be in a position to say, no, we were told about it much earlier?
No.
I mean, lastly on this point, if we look at UKGI 301 7966. UKGI 301 7966. Thank you. This is a reply of the Post Office to Tim Mccormac, one of his searching freedom of information requests. And he says, good to see the new spirit of openness in action yet again this morning with the publication of redacted copies of board minutes. Could you therefore provide me with copies of all board minutes in which is mentioned the clerk advice or clerk review? So he's after that information. And then looking at the bottom paragraph there, Post Office Limited has conducted reasonable proportionate searches and has identified 2 sets of minutes in which the clerk advice was mentioned. The minutes of a meeting on the 19th of November, which is the one that I just took you to, and the minutes of a meeting on the 4th of February, which is obviously later in 2021. So it seems that the Post Office rather agree that the earliest mention of the clerk advice of July 13 to the board was the 19th of November 2020. When it was revealed to the board, the clerk advice, did anything happen as a result?
That's I can't answer that question, I think, because
I'm thinking, Mr.
it's
Parker, something like, well, hold on, I've been in position now, speaking from your perspective, for 5 years or so.
And how come I didn't know about it?
I commissioned this guy called Jonathan Swift to look at things.
I get the gist of your question. All right. So look, this is 2020 or 21 or something like that.
November 2020, earliest mention.
Again, I have to put in context some of my answers here. Previous context I've given you is the Post Office wasn't just about Horizon. There were a lot of other very serious problems which I and the board were contending with. The context I'd give you on this is that I believe in 2021, we had 60 board meetings, something like that, to do with the fallout from this whole thing. So whether anything happened as a consequence of this, I can't tell you for sure. What I can tell you is that the amount of time and work and effort that I and other board members put into trying to essentially reconstitute this whole business from top to bottom might have allowed one of these things to sort of, just evaporate without anything happening as a consequence. So I can't tell you for sure what happened, but I can tell you this was an incredibly, incredibly busy time. You have to remember, if you take an organization and within the space of 6 months, you find out that the whole basis on which your business is being conducted was wrong, you find out that the whole basis of how you are somehow operating has to be changed. The amount of work to try and put things right, correctly so, I mean, all of these things needed putting right, but the workload was just immense and all time consuming. And whatever, I can tell you the new CEO and the new team were making strenuous efforts to try to put things right. So that's the context I would give, I suppose.
Mr. Parker, thank you very much for answering my questions. There are some questions from call participants. Could we take those, please, at 3:30, sir?
Yes.
Thank you very much, sir. Good afternoon, sir. Can you see and hear us?
Yes, I can. Thank you.
I'll just wait for the room to settle down a little.
Mm-hmm.
So the questions are, to start with, from Mr. Henry, up to 30 minutes, Mr. Steen, up to 10 minutes, and then Miss Patrick, up to 10 minutes.
All right. Thank you.
Mr. Parker, together with this page, Nigeria, I represent of core participants, including Seema Misra and Mrs. Teju Adedeo. I want to start off with some general questions, if I may. The first is the Sir Anthony Hooper argument. Did it ever occur to you that the SPMs who ended up being prosecuted or milked for shortfalls were hardworking people trying their best to put food on the table for their families in their own self-reliant way? And therefore, why would they resort to stealing from their own businesses?
I think the way you put the question, there is a, with hindsight, it would appear that, and this was the scale point I was trying to make earlier, which is that if I had seen, I think, at the outset, how many people had been convicted and how many people had been terminated or had an employment issue because of apparent shortfalls, I think the scale of the problem would have been apparent. And I think part of the lack of response or immediate response partly came from this apparent scale, if you like, of how many people there were relative to the population of sub-postmasters. But you're absolutely right. I mean, you know, when do you start to question whether people are honest or not? How many people do you need in a population before you think, well, can't be the case, they're all crooks or whatever?
Well, I'm going to come to that, and fortuitously, that was my second point. Because we're notifying the government of the liability regarding convicted sub-postmasters, so not dealing with civil, but purely criminal. In your letter to the Secretary of State, you mentioned that 959 cases had been identified in which horizon evidence had been used to secure a conviction. Do you remember that letter?
When was that written, please?
Well, we'll put it up on the screen. Yeah. It's POL 000 31104. And you can see it's 29th of April 2020. And if we scroll down, I can never get it right either, whether it's down or up, but you'll see that there is a reference to 959 cases. It's the penultimate line on the screen.
Yeah.
I take it from your answer, your previous answer, that you never questioned the conventional wisdom that this huge portion of sub-postmasters was dishonest, and that this statistically significant number of allegedly dishonest sub-postmasters did not make sense.
The point I was trying to make earlier, and maybe I didn't make it clearly enough, was that when I turned up and I asked for the Swift report to be done, and we did all of that, the way the problem appeared to me was that there were 130 people, I think, going through mediation, or 136, and there were 23 cases that were going through the CCRC. What I was trying to say earlier was that I actually didn't become aware of just how many of these people had been convicted until quite late in the day. And you might say, well, why didn't you ask? And that's the point I was trying to make. With hindsight, we could, and perhaps this question should have been asked, was that I know 23 people are going through the CCRC, but can you tell me, please, how many people have been convicted over the last 15 years? And that, you know, might have precipitated a totally different response to this thing, because as I was trying to explain earlier as well, you can look at it through the lens of, was the computer system reliable? Or you could look at it through the lens of, how come so many people have been convicted? And how does that compare with the average for people being convicted in a retail business, for example, which is one of the questions I ended up asking. So I know it's an unsatisfactory response to you and your clients, but if this thing ever happened again, and the issue was some people have been convicted, one of the first questions to ask is, well, out of a population of how many, and how many other people have been convicted who aren't complaining or aren't going through mediation?
So do I take it again that that work, that statistical analysis, came far too late?
I'd have to agree with you on that.
Right. Now, I want to move on to a different subject. And I appreciate that you were very much, as it appears, reliant on experts. But the recusal decision to unseat Mr. Justice Fraser, did you, notwithstanding the advice you received, take into account or recognise the impact that would have had on the sub-postmaster's ability to secure an outcome in their favour? In other words, did you reflect that if you had been successful, that would have killed the claim stone dead?
So I think one of it's not a paradox exactly, but as I said at some point today, it always seemed to me that had this been managed in a more cooperative manner, the civil proceedings, it could have, and perhaps should have, ended up with a judge-determined set of decisions around the contract and the reliability of Horizon. Of course, what happened was it was an adversarial combat, and each side was trying to win. And the recusal was one decision that could have stopped your client's case dead. I'm sure there were other things that, had they lost, would have ended up with a termination to the claim. For example, if the judge had decided in the common issues trial substantially not to change the agency arrangement, that might have changed things as well. So my take on it is, you're right, had the recusal thing been successful, it could have stopped the case dead. I mean, again, it must seem perhaps somewhat naive in retrospect, but my intention, and I had hoped with these proceedings, that we would fight, a sort of fair battle. And I think one of the issues was the legal teams got into a sort of we want to win litigation without at virtually any cost. And we got into a situation where people were doubling down, and the recusal thing to me was a doubling down thing in retrospect. So, for me, this is one of the most unsatisfactory aspects of the whole GLO.
Did you feel, do I take it that you felt that you had, as chair, lost control of the litigation? Because obviously these things were being done ostensibly shorthand in your name, but you appear to, by your answer, suggest that the lawyers had got out of control and that they doubled down and it had been adversarial, and that you had, together with your colleagues, nothing to do with it.
So, look, Mr. Henry, it's not my intention to release myself from responsibility for these events. When you're the chair, the buck stops with me. So for me to try and characterise this as, it's all down to the lawyers and it's nothing to do with us, that's certainly not my intention. I think what I'm trying to highlight is in the balance between the client and the lawyers. Sometimes the shift goes too much in one direction, and instead of being, the dog, it's the tail starts to wag the dog a bit. And I think the tail was wagging the dog a bit when we got to this. The recusal thing, as I said, I think I had misgivings about it at the time, and it's again, I tried to make the point. I don't know how many judges are recused, but I imagine it isn't very many.
Now, Mr. Parker, moving on again to a separate topic, and I assure you that there is some purpose to it. When you sent out letters of apology subsequent to the Horizon Issues judgment, reflecting on this now, Mr. Parker, was that performative, or was that a genuine expression of contrition?
So, the subject of apologies is quite interesting, because today I was toying with making an opening statement. Stand up, you say, "I'm deeply, deeply sorry," as many people have done. And there ensued a discussion with people, should I do this? Because, I would like to say sorry. And the response I got was that, well, you could do this, but actually, people have kind of got a bit tired of that, and it all rings a bit hollow, and you're probably just going to annoy people more than really give them any sense of your real desire to say sorry. And I'm afraid in these circumstances, it's very hard to either prove that your sorrow and apology is genuine. It's hard to find language which, if you attempt to express it in the extreme, just sounds as if you're being hyperbolic and simply trying to get effect. So there is no satisfactory answer to this. There is no real way to say sorry in a convincing way, because the people who've been affected just feel the damage has been done, and you're scrambling to sort of fill a small gap in that sort of failure to accommodate. So I don't think a good letter could have been written. I don't think any letter would prove to be satisfactory. And it's not easy when you've got a lot of people who are involved. So I know that's an unsatisfactory answer, but I'm trying to express the reality of the situation.
When you signed those letters, though, did you remain of the view, even after the Horizon Issues judgment, that the sub-postmasters who've been prosecuted or pursued in the civil forum were guilty, liable? I mean, I'm trying to ask you to reflect on how hard it was to let go of the idea that the sub-postmasters who had challenged and who had taken on the post office weren't at it.
I see the point to your question. And my view is that once we had reached the end of the trials, the game was up, as it were. And it was time to just, I've tried to, when you get a business that is so upside down in terms of its structure and its relationships, I can see why you're asking the question, but from my standpoint, I felt the game, we just needed to change completely. And with the new chief executive and the team, we have tried, or we did until I left in 2022.
So you don't believe that a mindset of blame still persists? I know you left in 2022, but you don't believe that a mindset of blame still persists within the organisation?
I can't speak for an organisation. I can only speak for myself.
Yes.
And it's, I would say that Nick Reed and his team have, at all levels, made a huge effort. Now, that isn't to say that some of the people who were working at the time of these events are still at the post office, because it's impossible to run an organisation, just clear everybody out, as I hope is obvious. But the mindset has been completely changed. And I would say when you have such a huge shift in culture to make, it's never made overnight. I mean, this is you have to appreciate, it's one of those slightly irritating aspects of these sorts of events, is that trying to put them right is no easy matter. And it requires determination at the top. And believe me, after the trials, I and the rest of my board and Nick and his team have done, I feel, as much as they can. The one area that I simply cannot speak for is money, because money, unfortunately, once the fact that there was a huge liability at stake, the money is no longer a matter for the post office, it's a matter for the shareholder.
I see. Well, I'm going to now go to a specific example where I suggest you see the mindset hasn't changed. Taking Mrs. Adedeo's case, what is your view on the Post Office's recent written submission to the inquiry, effectively branding her a criminal despite her conviction having been quashed? I mean, you may not be aware of it, but I can put it up on the screen if you like. I quote, "The inquiry will be aware that this, that is Mrs. Adedeo's case, is the sole case study where the Post Office does not accept that the conviction was unsafe." Do you unreservedly reject that victimisation?
First of all, we haven't got the letter yet. And secondly, unless I have got all the facts at my disposal, Mr. Henry, I don't think you can expect me to, deliver a black and white response on this. And I'm no longer obviously at the Post Office, which precludes me a little bit from knowing what all the background is.
Well, Ms. Parker, her conviction was quashed, and the Post Office still brand her a criminal. I mean, surely can you not reflect upon that and distance yourself from it and repudiate it?
I think I'd love to be able to just say, yes, Mr. Henry, it's absolutely right. Your client, I'm absolutely with you. Honestly, I haven't had the background, and I simply, much as I would love to sit here right now and say, yes, I would prefer to see the background first before delivering an opinion, and I hope anybody in my situation would see that's not unreasonable.
Well, if it helps, Mr. Henry, I think it's fair enough.
So be it, sir. Can I go to time, please, now? And I've got, having dealt with some general questions, some specific issues. Throughout your tenure, you had many competing obligations devouring your time. And you wouldn't be human if, from time to time, forgive the expression, they were distracting you. You would agree?
Actually, I've got a slightly different view to that. I would say one of the strengths of having multiple appointments is that you have got exposure constantly to what is going on in a range of different activities. And that actually means that you are well acquainted with the business world and other worlds, actually, and what's going on. And so I would say, and I tried to explain earlier, that being an effective chair is partly to do with time, but it's also to do with judgment. And I think one's judgments and one's involvement are actually improved by having a range of different things to do.
And that, curiously, and I'm sure that you weren't plagiarising it, was Mr. Leighton's similar explanation for the competing demands. But you have said yourself that it wasn't just about Horizon. There was an awful lot of stuff going on, in the business. And what I'm trying to suggest to you is that to reduce your time at this critical stage before the GLO must ultimately be viewed as a serious error of judgment. What do you say to that?
I say, actually, I gave, and as far as I'm concerned, Mr. Henry, I gave all the time and attention that I could and needed to at the Post Office. And I think if you talk to colleagues, look at the board effectiveness reports, just do a general trawl, go and talk to people at the Post Office, you will find that I was well acquainted with what was going on. I was always well briefed. When I was in a meeting, I paid very close attention to the facts that were under consideration. I chaired meetings well. So, no, I don't accept that assertion, actually.
I'm going to deal with this very quickly, Mr. Parker, but you are familiar, and you have seen, of course, in the pack that was sent to you, a number of emails from Mr. Tim Mccormac. And what I'm suggesting to you is that because of the enormous burden on your shoulder, not just simply from the Post Office, but other competing demands, this affected your ability to grip it personally and get involved in what he was saying in a meaningful way. And so therefore you were channeling his requests onto other people who were not serving your interests. In fact, they were delaying, denying, and stonewalling Mr. Mccormac. Now, would you like me to deal with the emails in detail, or...
Yeah, I understand, because I've read the emails.
You've read the emails.
And I understand the point you're making.
Yeah.
And I've tried to explain earlier that when I joined the Post Office, and bearing in mind most of these emails were probably around April 2016 and July or whatever.
Yes.
I think that's right. I assumed, perhaps with hindsight, incorrectly, that the people who were advising me were honest, were competent, etc. And in virtually every other company I have been in, when I get a sort of email or letter that comes in, which is essentially about a legal matter and says, in capital letters, I will say, what's going on, and take it away and give me some background. And I understand the point you're making, but I can honestly tell you, Mr. Henry, that whilst, it might appear that we should have grappled with Tim's points and really concentrated on them, and it's very unsatisfactory looking back to see that it was handed over to a bunch of people that we, arguably weren't going to handle it well. Those were the circumstances at the time. I'm not trying to get out of responsibility here. Some mistakes in that respect were made. But I honestly wouldn't say that was a function of me not having enough time as such.
But if it wasn't a function of you not having enough time, then why would you not wish to go to the ends of the earth to establish whether or not an innocent woman had been imprisoned?
Because this was an individual case, which I think was going through the CCRC. I can't quite remember the context. And actually, I have tried to grapple with this thing largely through the collection of issues that were brought together. And you're right. I mean, perhaps had one rushed after the Misra case, there might have been some progress. I can't honestly tell you. But if what you're implying is that somehow, because I didn't deal with this thing, we didn't really do anything, didn't really care about this, didn't try to resolve it, I don't think that's really fair.
What I'm trying to suggest, you've talked about the wall being built. We've seen how your reception into the Post Office was being prepared. I'm going to call it a grooming pack. Prepared by Mark Davis, that they were trying to get you on side, and that notwithstanding your genuine desire to be independent, notwithstanding the fact that you had no axe to grind, that gradually you were compromised, and to use the analogy of the wall, you became immured in prejudice. What do you say? The institutional prejudice of those people that you relied upon and trusted who surrounded you.
What I will say is this. Behind a set of events that we have been discussing today are a complex mixture of interactions between people. Some self-consciously driven in a particular direction, others not, others just being part of it. And so, whilst your characterization, I think, probably has some truth to it, matters are far more complicated than that. And I would say, in some respects, yes, the wool might have been pulled over the eyes, and in other respects not. Sometimes happened, sometimes didn't. But there isn't it's very unsatisfactory, but it's like, here's a set of wrongs, and we put them right, and how do the wrongs happen, and exactly, where are the root causes? And the root causes of this thing, of course, at the end of the day, probably reside in the software. The root causes of the problems we've talked about today reside in the process of investigation. The individuals, and this is the point I was trying to make, a lot of the problems that we have looked at happened between 2000 and 2010, quite historic. And trying to overcome history in a business when history is so damaging is a tough thing to do. So,
and all the more reason, therefore, for people who feared what impact that could have on the GLO to keep it battened down, to keep it hermetically sealed, so that none of that would escape. Do you see?
I do. I understand the point you're making, and I tried to express this earlier, which is it's got a slightly unsatisfactory tinge to it because, of course, it implied that Sir Alan and the Jfsa team had to spend money and had to get support to mount the GLO. But the GLO, although one might have a lot of aspects of dissatisfaction about the way it was run, actually did end up with a judge making determinations which will change the post office forever and actually set up a situation in which your clients, in time, should be properly compensated because there's been an absolute clarity in terms of what was responsible for what.
Ms. Parker, I have to be brief, and I don't want to be unfair to you, but I've only got a couple of minutes left, so I just want to ask you if you feel that the answer you gave to Mr. Beer about that this really had to be resolved, as it were, adversarially, was somewhat fatalistic, and that more could have been done to strive to see the other side and to strive for settlement without having to enter into the quagmire of litigation.
Yeah, I mean, there's no satisfactory answer to this. I played out, so there had been an early settlement. I could easily imagine a situation in which your clients would be worse off because instead of waiting until the end when it was absolutely determined by the judge that Legacy Horizon was not robust and Horizon Online wasn't robust, you could have ended up in a situation where computer system quite robust. This is the point I was trying to make earlier, where I played out. So the post, and I know it's I'm not trying to escape, responsibility, but if we'd sort of said, well, we think we've got a problem with the computer system, it's not reliable. The moment you start to get to there could be miscarriages of justice, there could be a huge liability here, then the question starts being asked, well, what's involved?
Could I, final question, please? And I have to compress two documents, but there are two documents noted by Peters and Peters, it would seem, but involving a number of lawyers. And one reference is POL 0033745, dated the 24th of January 2020. And so that's long after the Horizon Issues judgment. You are not present, Mr. Parker, but you and Mr. Cooper, it is said, wanted to take pot shots at Seema Misra. Do you have anything to say about that? Do you recall any research being done on what claimants, convicted claimants, had said in open source material to try and trawl to see if they had made previous inconsistent statements so that their credibility, even after the Horizon Issues judgment, but before the appeal, the criminal appeal, could be impugned? Do you remember anything of that nature?
I don't, and funny enough, this document appeared fairly late in my bundle. I did have a look at it, and it is apparently a sort of abbreviated description, isn't it, of barristers' meeting, I think. Yeah.
Yes.
Well, look, somebody writes taking pot shots. I don't know what that means to you, but it's a fairly colloquial sort of, I don't know what they were trying to express, but I'd love to have Tom Cooper in the room here, but I can assure you, neither of us, would have been attempting to deliberately somehow undermine a situation that had been, effectively determined as a result of the trials. I think I just don't know where that comes from, honestly.
And finally, do you recognise the suggestion that the board looks at lawyers purely from this perspective? They see lawyers. This is Roderick Williams speaking on behalf of the board. Sees lawyers as interchangeable tools for optics. Legal advice is polluted product for the Post Office because of the High Court litigation. Is there any suggestion that you and your colleagues did see lawyers as marionettes?
Can you, sorry, what's the point? What's the point you're trying to make?
The board is reported to have told the lawyers not to advise on safety. And Roderick Williams goes on to say, quote unquote, the board sees lawyers as interchangeable and tools for optics. You said that you didn't see lawyers as marionettes, but I mean, this suggests that perhaps if this note is a fair reflection of your point of view, that you did.
I don't. Is this a Roderick Williams note? Is it? I don't think Roderick really reflects an awful lot of what certainly I think or the board thinks.
Okay. I think I've run out of time, so I'm going to stop there. Thank you, sir.
Thank you.
Thank you, Mr. Henry.
Mr. Parker, my name is Sam Steen. I ask questions on behalf of a large group of sub-postmasters, mistresses and people that worked in post office branches. You'll recall having dealings in at least 2019 with a Mr. Swannell. At the time, he was the chair of the shareholder executive, and that was later renamed into UKGI, which is the UK Government Investments. Okay? Now, when you get to the end of 2019, there were discussions that touched on the question of settlement. Do you recall that? Okay. Now, help us please a little bit with this. Mr. Swannell will be giving evidence next week, I think on Tuesday. And his recollection is of having had a word with you sometime in June 2019, whereby you thought the estimate of the amount involved in the settlement might well be something in the order of 100 million. Now, contextually, we know that the settlement was in the order of essentially 50 million. Okay? Now, that's quite a big difference. The 100 million, was that what you thought it was worth, or was that what you were told this may well come to?
Honestly, I'd like to see the papers because it's quite hard for me. 2019, 20, 100 million. I'd love to be able to give you a definitive answer, but I can't on that.
But do you have a recollection? Because it's only his statement where he refers to this. I'm not sure we have papers. that refer to this.
I-
You give a recollection as to whether there was
Yeah.
any particular barrier, as an example, to 100 million or
Well, all I
that
will
was being
say,
discussed?
okay, all I will say to you, and again, I'm not trying to, escape responsibility or liability or whatever, is that whatever discussions happened post the litigation, the whole the money only comes from one source, and therefore, whether the post office quotes the number or there's another number, ultimately the decision isn't going to be made really in the post office.
Right. So essentially, you're saying by that point,
By that point,
it's for the government as the
the
shareholder.
post office could not probably run, and maybe it can now, but certainly in my time there, I don't think it could have run as a standalone business. It needed constant support from the government.
All right.
And therefore, any additional cash requirement was always going to be an incremental government decision, one way or another.
So before I move on to another topic, your recollection of the figures in relation to the settlement was, one, the money was always going to have to come from government. Yes, is that right?
Ultimately, yes.
And secondly, Mr. Swannell's recollection of discussions around 100 million, and in fact it being considerably less than that, clearly demonstrates that there had been discussions at potentially quite a bit of a larger figure at some point.
Look, I don't want you to put words into my mouth that are subsequently contradicted by someone else, so I can't give you a definitive answer to this, honestly.
Okay, but you're not saying no. What you're saying is you can't really remember. Is that fair?
That's exactly what
All
I'm
right.
telling you,
Okay.
yeah.
Now, I'm going to go, therefore, to a document you've looked at with Mr. Beer a little earlier. Can we go to POL 00174-397, please? And I'd like to go to page 2 once we get to the document. So do you recall quite early on in the questions being asked by Mr. Beer that he was discussing with you this note, which is a note that was meant to have emanated, as you understood, setting out some of the concerns at that time. Now, you said repeatedly a word you use is context. So let's understand the context of things. So the context of this note is you come into a business that's overall in crisis. You agree?
Yes.
Yes. Fundamentally, this is a problem business in terms of needing to be turned around, yes?
Yes.
Okay. You've been chosen over another possible candidate as being the right individual to have a go at doing that, yes? And
Yes.
you wanted to find out more about what's going on. Again, you're saying yes, you
Yeah.
agree.
Yeah. I'm just wondering where this is going.
Well, let's see where it's going in a moment.
Yeah.
We know also from your evidence that you've said that the whole basis of the business and the way it was being conducted, you referred to that being questioned in the litigation because it's about the Horizon system.
Yeah.
Okay? So when you came into the post office in the role that you took over, you must have realised quite rapidly that questions regarding the Horizon system integrity were also questions that were threatening the whole business. Is that fair?
Looking at this, as I've tried to explain, in scale terms, it didn't look that big in relation to the population of sub-postmasters, the number of people who were complaining, the number of people who were convicted. And most of these issues were to do, obviously, with what you would call historic Horizon. So, from my perspective, we had a set of issues that were people who'd had historic problems with Horizon, and then there was Horizon as an EPOS system, which operated post offices, effectively. And the two things are one is sort of business as usual, the other is a whole set of issues that people had with the system historically. So this, as I tried to explain earlier, this was one of a number of problems.
Right. Now, you said that a number of times. That's your context point, number of other problems dealing with the business. But this is This is about the Horizon system. It's questioning the integrity of the system. You agree with that?
A component of it is.
Let's have a look at how serious this was then. We go perhaps to the bottom of page 2, if we may, please. I think we're there already. And fourth paragraph from the bottom. Just go up a little bit. Yeah. We see the bottom. That's it.
Yes.
Right. So we can see that the references here, obviously, to the Jfsa campaign.
Yeah.
We can see that the BBC Panorama programme. We can see references
Yeah.
to MPs that are also engaged. And
Yeah.
Scroll a bit further down, please. It's my fault. Let's go up again. Fourth paragraph from the bottom.
Yeah.
Yeah. Okay. So the one that starts, we've been robust in rejecting the serious allegations made in Parliament.
Yeah.
See that one?
Yeah.
Made in Parliament and media, particularly in recent months. And then it goes on to talk about the issues that concern the campaign's allegations have grown to include suggestions of wrongdoing by senior management, bullying, deliberate cover-up, and abuse of prosecutor powers. Now, these are serious allegations.
Yes.
Now, accepting your point, which is that in your mind, you've got a problem which is you think may well be largely historical, maybe an older part of the system. Okay. But this is, in fact, actually questioning the integrity, not only of the Horizon system, but also of management at the very time you're coming into it. So it's raising the very question that Mr. Beer was talking about with you, which is, well, hang on, are the people around you people that you can trust? Right? Serious allegations.
Yes.
In fact, allegations that, if true, would be the death knell of the business that's already in crisis.
Well, I'm not sure I would go that far, but you're right to highlight that, yes.
Okay, well, let me highlight then and see if I can be right about something else. Page 1, third paragraph down, please. Now, I use the term paragraph, the three main paragraphs from the top under note for Tim Parker. Okay. So it says this: the Horizon system deals with 6 million transactions every day and has been used by almost 500,000 people since it was introduced. Currently used by 78,000 people working in post office branches. It is independently audited and meets or excels standard industry accreditations. Let's take that apart. Did you receive the independent audit of the Horizon system at this time?
No.
Did you ask for the independent audit of the Horizon system at this time?
Which independent audit system are you referring
back to the third paragraph from the top, the one I read out. The Horizon system deals with 6 million transactions every day and has been used by almost 500,000 people since it was introduced. Currently used by 78,000 people working in post office branches. It is independently audited.
Okay.
So I'm stopping there for the moment. Did you see the independent audit at this time?
So, essentially,
it's a bit of a yes or a no question.
No, can I just finish,
yes,
please? I think I'm entitled to that. I understand the question that you're asking. Essentially, I didn't ask for the independent audit. This was something, obviously, that's been put into the brief. Now, I'm not quite sure. Can you just explain to me where you're going? Yeah,
I'm asking the simple question. I suspect the answer is either yes or no.
Yeah.
It looks like it's no. Did you see the independent audit? The answer appears to be no, you didn't. Is that fair?
Well, if somebody says something is independently audited,
yes,
that can mean a number of different things. It can mean somebody's gone in and looked at it, or it can mean there's I don't know. But if you're asking, had I got the independent audit? No.
Did you ask for it?
I don't think I could have done.
Right. Why couldn't you have done, Mr. Parker?
Do you know?
Is that you saying you didn't have the power to, or you saying that you just didn't?
No. This was a brief that I received, and we've looked at this Sparrow brief, and it's earlier, and this is all about. So, what actions could have been taken that might have landed us in a different direction. And maybe you're right. Maybe there was an audit. We could have asked for it. I could have asked for it, and it would have said, this is okay, or, you know, it would have been something that was inadequate. I'm not entirely sure. And with hindsight, there are many things that we could have done. Swift, which we discussed extensively, whilst not being perhaps brilliant and perhaps a bullseye and perhaps spot on, covered off a lot of the bases. And if the question you're asking is, you know, is there something that definitively could have been done that would have pushed us in another direction, I'm not entirely sure.
Mr. Parker, I'm asking about your decision-making. I'm asking about your responsibility.
Yes.
I'm asking questions that go to whether, and to what degree,
Yes.
that you have made mistakes. Do you understand that?
I
So
entirely
your answer to my
understand it.
question to the independent audit was this: I don't think I could have done. Now, I'm trying to find out now, with my follow-on questions, whether that means you didn't have the power to do it or you just didn't do it. Which?
I think I could have had the power in theory, I suppose, to do many things.
Right.
We, you know, as I said, I didn't ask for the audit, and it, you know, I don't know what this was referring to. We moved on to Swift.
Okay. Now, it then goes on to say this paragraph, and meets or exceeds standard industry accreditations. Did you ask for those?
I can't tell you right now because, you know, this is a long time ago.
Do you recall seeing the standard industry accreditations for the Horizon system?
I don't think anybody plonked them on my desk, no, but I'm not entirely sure. I don't think so.
2 paragraphs down, we commissioned, it starts. You see that one there? So further down, we commissioned, thank you very much. So it's got a little yellow dash to the left. We commissioned, past tense, a review by independent forensic accountants. Okay? Then it goes on to set up a scheme which, where appropriate, offered mediation, etc. All right. Now, reminding of us of the timing of this. This is 2:15, at the time that you're engaged in dealing with matters. All right? We know that what this must appear to be is second sight, which is back to 2013. So it says we commissioned a review by independent forensic accountants. Did you ask to see that?
The second sight report we saw as part of the whole setting up of the Swift review.
Did you see it as part of this? Do you get this and say, I need to see the independent forensic accountant review?
I can't tell you exactly when I saw it.
Right. So what we have established in your evidence with Mr. Beer, first of all, and obviously with me as well, what we have established is that you came in, you were given this briefing, and then you decided that you needed to have somebody else look at these issues, and that was then Mr. Swift.
Yes.
QC, now KC.
Yeah.
Right, okay, got it. Do you accept that what you should have done have been more hands-on, saying, let's have a look at this stuff myself, I want to see it on my desk, I want to talk to the IT people, maybe talk to Fujitsu? Do you accept you could have gone more into this yourself?
I have tried to explain earlier, I think, that whilst you might say the Swift review was inadequate and we should have gone straight to the IT system and done an audit, that is one of a number of possibilities. And what I tried to do was to get somebody who could look at the range of issues, and the Horizon system was one of them. So, you know, if I had seen, I suppose, and I mentioned this earlier, the scale of the thing, that might have been different. But I responded to this, honestly, in the best way that I thought I could. And I felt Swift was a pretty good response initially. Now we know, with hindsight, we go down this sort of sparrow briefing. I can see your point.
You see, one way to look at the difficulty with the amount of time that you were spending on this is that you were part-time and your decisions were part-baked.
Yes.
Understand that, Mr. Parker? You said repeatedly that the time issues, this is the same amount of sort of time that you might spend with other businesses, that the role of the CEO is like that, that you have a direction rather than necessarily getting down to the grips with the nitty-gritty all the time type role. But this isn't the National Trust, is it, Mr. Parker? This is the Post Office, responsible for prosecuting its own staff members. Don't you think that more time should be spent by you getting to grips with these very issues?
I don't accept that. I
Right.
gave sufficient time and attention to the Post Office. I'm sorry.
Our time is limited now, myself, in relation to questions. I'm going to take you...
You've already taken double the allocation, Mr. Steen, so one more
only
question.
one more minute. You say this in your statement, paragraph 59. This is in relation to the Swift report or review. And you quote in your statement part of the Swift review, where it says this, in relation to bugs. So paragraph 59, page 27 of your own statement, all right? Swift review. It seems to us entirely unremarkable that a Horizon system, which is enormous in terms of the range of matters it deals with and the number of users it has, will occasionally discover bugs, errors, or glitches in the way that it works. And then you continue the quote. Some of those bugs may impact on the financial position of a branch, either positively or negatively. We do not understand POL or fujitsu to suggest anything otherwise. Now, Mr. Parker, when learning from the Swift review that this system, the Horizon system, may in fact cause negative impacts on the financial position of a branch, did you not think to yourself, hang on, that sounds remarkably like the people that have been making all that noise from the Jfsa, and decide there and then to do something about it?
So Swift, I felt, covered off a range of issues and covered them off quite comprehensively. And I took away, perhaps wrongly, that Swift, whilst it wasn't a green light, was not a red light either. And what you've done today, I think, has sort of picked up on a number of points which, with hindsight, we might have gone after. And this is one of the frustrations and difficulties of looking at something like this over a long period of time with a great deal of complexity. And, you know, I could reel off a bunch of other things I could have done that would have ended up with probably a quicker situation. But I come back to the point I made earlier, which is that the extent of the issues that we had arrived at meant that no matter how unsatisfactory, the ultimate determination of the reliability of the computer system and the contractual position with said postmasters has facilitated a long-term solution to this problem.
All right,
So thank you for your indulgence. No further questions.
Oh, that's fine. Ms. Patrick.
Thank you, sir. Mr. Parker, my name's Angela Patrick. I represent a number of sub-postmasters who were convicted and have since had their convictions quashed, included Mrs. Hamilton, who I'm sure you can see sitting beside me.
Yeah.
You might be glad to hear that I only want to look at one issue. I want to turn back to the follow-up to the Swift review. And I actually only want to look at one example, and that's the advice of Mr. Altman, then QC, now KC, produced on the 26th of July of 2016 for the Post Office in response to the Swift review. And I want to start just to look a little bit at what you say in your witness statement about that advice. Just to refresh your memory. I'm not proposing to turn your witness statement up in case you need me to refresh your memory. If you do, say so. In your witness statement, you say, and it's at paragraph 113 for those following along, that it's likely that you would have been briefed on that advice from Mr. Altman, but you can't recall now what you would have thought about it. Now, just to clarify, do you think you did see a copy of the advice, or is it likely that you didn't?
I mean, I'd like to be able to confirm to you one way or another, but I honestly can't.
No. But you would have been, you recall that it's likely you would have been briefed?
Yes, let's say, let's work on that principle if you want to take your point further.
It's not principle, I'm going on your evidence from your witness statement, Mr. Parker. And in your witness statement you say you'd probably have been briefed by General Counsel.
Probably.
Now, elsewhere in the witness statement, you reflect on the advice, reading it now, having been provided with it, and you can't remember if you had it at the time, and you reflect on the broad conclusions, and you note that there are some criticisms that Mr. Altman made that went beyond the scope of his instructions. And I just want to ask you about a couple of things, two things from the advice.
Yeah.
First, in your witness statement, you note that he reviewed 8 files.
Yeah.
And he considered 3 cases.
Yeah.
Yeah. Now, Mr. Beer took you this morning to some correspondence which you didn't see, narrowing the scope of Mr. Altman's instructions to cover 19 cases, if you remember. You hadn't seen that. Did you know at the time, if you can remember, that the scope of his advice had been narrowed still to 8 cases?
Honestly, I don't know, and I can't tell you.
No. And you can't, I assume, recall whether the briefing would have covered whether the review, the advice, had been narrowed to report only in 8 cases.
I can't.
If you had known, and you'd been told at that time, having read the Swift review and what he'd recommended, that you go back and look at all the cases, if you'd read at the time that he was only going to look at 8 cases, in fact he could only analyse 3, would that have caused you any concern?
Well, it's funny you should mention that, because I read through the documents again, and I was struck a little bit that, you know, the case population wasn't enormous. I did note that.
And if you'd seen it at the time, maybe it would have caused you to ask, hang on a minute, can we really rely on these headline conclusions?
Well, I've tried to explain that I think one of the core issues with this thing was was percentages of the populations of people that were actually looked at. So, you know, as we've discovered, a huge number of people.
If I can stop you there, Mr. Parker, whether it was 136 or it was 900 and odd, if you were getting, I'd like to say, probably expensive legal advice from a criminal silk, on the advice of Mr. Swift, on whom you were relying, that all the cases should be reviewed, and you were being told that only 8 cases were being looked at, and in fact he was only going to analyse 3, would that not have set up a red flag for you?
Yeah, well, I said I looked back at the advice, and it you know, you're right to point out at the time it seemed relatively reassuring. Yeah.
But if you had seen it, would you have not said, hang on a minute, we're only looking at 8 cases?
I might have done, yeah.
Okay. Does that help with your memory as to whether you read it or didn't read it at the time?
Honestly not, no.
Okay. Turn to the second thing I wanted to ask you about. Now, Mrs. Hamilton was one of the 3 cases.
Yeah.
And I only want to look at one part of the advice which deals with the circumstance of Mrs. Hamilton's plea only being accepted on the condition related to repayment of money.
Yeah.
And it's at Paul 3022854, and I'm going to look at page 27. If it's okay with you, Mr. Parker, for time, I'm just going to take you to the 2 paragraphs I want to look at. You can trust me that it's the advice.
Right.
If somebody could bring that up, I'd be grateful. And I want to look at page 27, and it's paragraphs 106 and 107. Thank you. And I'll just take it briefly, I'll read it so everybody knows what I'm talking about. He says, the proposal here, however, ultimately to invite the court to order the count to be left, that's the count of theft to be left on the record, on the file as a condition of repayment, was highly unusual, if not exceptional, and it was, it seems to me, fraught with difficulty, despite the judge approving the course. First, the effect of the arrangement was that the prosecution was in effect allowing Mrs. Hamilton to buy her way out of a charge, upon which the in-house lawyer and counsel had advised there was sufficient evidence. Second, the question might be asked, why, if the prosecution felt the evidence was sufficient to support the count of theft, it was content to drop it for repayment of the losses. Third, if Mrs. Hamilton did have a tenable offence to the count of theft, although I've seen no defence statement providing any defence, undoubted defence statement was ever served, then it might be argued that the suggestion she should repay the losses in return for the dropping of the theft count, I apologise, I'll pause. For the dropping of the theft count, which was an idea originating with prosecution, placed undue pressure on her, despite the fact that she was represented and despite having pleaded guilty to false accounting. Now, I apologise. Now, that's an important, serious criticism, isn't it, Mr. Parker?
Yes, I mean, he goes on. I mean, it's quite hard for me to comment on this. There's a lot going on in this paragraph. There's a lot going on the whole page. And I haven't got the whole document at my disposal. So to ask me to comment, you know, on a specific case, I think is, unless we have proper time, and I'm not, yeah, go on.
I simply wanted to ask,
Yeah.
did you see this at the time, or were you briefed on it, and would you, if you had been, have considered it a serious matter?
So I can't tell you if I saw it, and before opining on how serious a matter I would have considered it, I'd have to look at the whole document again.
Okay. Did your briefing at that time, I know that you can't remember it, but just to try and prompt your memory, can you recall if it recorded any discussion of specific matters or criticisms that ought to be considered for referral to the CCRC?
No, I can't.
And you've spoken today about the advice you were given on privilege in the civil litigation.
Yeah.
Did that briefing or any advice you can recall being given around the time of this advice cover the Post Office's continuing obligations on disclosure as a prosecutor?
I can't, I'm sorry.
At this time, when you were being briefed or when you read this advice, you would have been aware, I think, that the rest of the board wouldn't have read the Swift review or its recommendations. Is that right?
Possibly, why?
Well, you knew that they hadn't, that only the 4 internal staff had been given it. You had a copy. It was being controlled. You knew the rest of the board hadn't seen the Swift review. Is that right?
But I'm sorry, what's the point you're making there?
I'm asking
Well,
you a question.
never mind about that, Mr. Parker. Just say yes or no.
Okay, yes. Or
Yes, you
no.
knew.
Yeah.
So, at that point, nobody else on the board could have judged if Mr. Altman had or had not done what Mr. Swift had recommended, could they?
Well, I'm not sure who the Altman advice was shared with, actually. This was one of the outputs of the Swift review.
That's why I put the question in the way that I did. You had seen both the Swift review and were being briefed or had been shown a copy of the Altman advice. You were uniquely placed. Nobody else could compare the two and say, well, Mr. Altman's kind of not done what the Swift review expected him to do. You were the only person that was in the position to do that, apart from staff. Is that fair?
Yeah, I think at the time I just took this advice, which seemed to me to be an adequate response on the first and second recommendation. I think, you know, I wasn't busy comparing things. It just looked to me, and I think I was told. I think I was told at the time this met the brief.
Oh, Mr. Parker, I'm not trying to be flippant here, but you're saying comparing one thing or the other. This is a very serious question of whether the Post Office had met its prosecutorial duties to people who it had convicted of criminal offences. So, being the only person on the board who could assess whether or not the advice that the Post Office had commissioned was actually what it sought to obtain, put you in a particular position. Did that at the time cause you to think that you really ought to be looking really critically at the advice the Post Office was being given?
I can't honestly tell you.
Okay, today you've relied a number of times on a belief that legal advice given to you was competently given in good faith. Did you owe any responsibility to the board and to the business and the government shareholder to actively question or challenge that advice you were being given?
I think, as I explained earlier, to challenge advice of specialists invites the question, you know, how do you challenge a legal opinion? And I don't have an easy answer to that.
But at a minimum, you would have had the responsibility to at least properly consider the advice you were being given in good faith. Is that fair?
And I believe I did at the time.
And you can't recall now if you ever saw a copy of the Altman advice.
I can't for sure.
Can you recall if you asked to read it for yourself?
I cannot. I'm sorry.
Thank you, Mr. Parker. Thank you, sir. I have no more questions.
Thank you, Ms. Patrick. Is that it, Mr. Beer?
Yes, it is, sir.
Well, thank you, Mr. Parker, for making a full and detailed witness statement and for answering questions during the course of today. I'm very grateful to you.
Thank you.
We'll resume, I believe, next Tuesday. Is that correct, Mr. Beer?
Yes, 9:45, please, sir.
Very well. 9:45 next Tuesday. Thank you.
Thank you, sir.